That's what
You mentioned before the Justice Mukherjee.
Yes.
What about the pending application? As per the determination.
Frankly, Justice Mukherjee has a very vast determination. He's taken appellate side matters. It will take a lot of time. We are suffering for 3 years. Admitted claim. Admitted claim, Milord.
So now what
No,
you want?
admitted claim, but he has been heard before Justice
It
Mukherjee
has
for
been
days
heard by
together.
Justice Mukherjee.
Let it run in my lord's list. That will be easier for us because
Huh?
otherwise it will be very difficult for
What is
us,
your
Milord.
submission? You don't want to release this matter.
Yes, Milord.
But if the matter has been heard by the one judge,
Substantial,
there
at
are
least 15
there are
days.
connected matters, Milord.
connected matters will be taken here if it is not been heard. If it is heard, the judge.
Milord, we are suffering for more than 3 years, Milord. Upon an admitted claim.
No, but
Milord,
question
kindly
is
appreciate.
not on
Milord.
the
Kindly
merits.
appreciate.
Question is
Okay,
whether,
let it become as a to be mentioned on
but,
12th April.
To mention matter, this matter already, the examination in chief has been completed of the plaintiff. But in the meantime, we have found certain cogent documents we have discovered. These telltale documents, we need to disclose it. By today, we are giving them notice.
Who is for the other side?
No. I have mentioned about notice. Without notice, I never mentioned about my lordship.
Who is appearing? You.
Yes, my lord.
So it is on 1st April.
No, it is tomorrow. 3:45. Will you appear on 1st April, my lord?
Tomorrow at 3:45.
Let it appear tomorrow. Let it appear tomorrow, my lord. Whatever submissions is.
Achha, 22nd and
Yes, my lord. Tomorrow's date, my lord. Wasting post time is my lord not right. My lord, I am just mentioning, my lord. I am today by 2 o'clock. I'll give them the documents which we have come on. They're serious documents. They are documents which they have deliberately.
okay, you
Lord,
I am opposing,
Lord. One day before the matter.
The matter is already fixed tomorrow. Whatever you saw the copy, come tomorrow. We'll see.
Yes.
may I have your lordship's kind leave to
Yes.
mention one more matter? Lord, for extension of interim order, which is expiring on 31st of March.
Yes.
My lord, any day before 31st.
Bank is matter, my lord. Bank is suffering interim order since long. My lord, kindly fix this matter for hearing as upgraded matter. It has been in listed in 16 and 16
Well,
and 19.
that I don't mind, but kindly 31st March, kindly extend the interim order.
It's the date, my lord, short date. The bank is
Yes.
suffering interim order since long.
It fixed tomorrow as to be mentioned as a top for extension of entry.
My lord, when is your lordship?
Tomorrow as
Tomorrow,
to,
I'm
at
so
the
deep.
top as it to be
Yes,
mentioned
sir.
for extension of entry.
So,
Then I will fix the date. I will extend and I will fix the date for here.
My lord, may I have my lord's leave, my lord, to mention 4 plaints, my lord.
Why?
All of them have been admitted, but my lord, upon scrutiny, my lord, some defects have arisen. My lord, leave is required from my lord to correct.
That's why yesterday also somebody has
My
mentioned.
lord, I only mentioned your lordship had asked me to come
See,
today.
what is the yes? Come today.
The plaint has been, my lord, notarized in Delhi.
Maybe
So, that is
if
why.
it is any defect in the plane found by the master and master is not able to cure the defects and he wanted the leave from the court.
Yes, my lord.
If the brief has not come to the court record, how the court can ascertain what is the requirement without the document, how the leave can be granted? Yesterday also some of the advocate has mentioned in half an hour the time was wasted for this only. If the master is found it is defect, it is the duty of the master to place the record before this court if the master is not having the authority to cure the defects. On mentioning how the court can give the leave to you.
Lord, I'm not aware whether the records has been placed before
No,
my lord.
record is not been placed. They are not placing any report before this court. And advocate, if I grant the leave,
Yes, my lord.
what leave is to be granted without that document?
The document.
Tell the department to send the brief with the report. I will pass a prepared order. Without the report, I will not pass any order. I will not give any leave.
Very good. So, if my lord may kindly keeps the matter under to be mentioned, my lord,
Not,
direction.
why? It is not.
A direction may be passed upon the
Let
master.
the report come. Let the report
Milord,
come.
may be
Very
permitted to mention one matter. Milord, the coordinate bench of this honorable court had passed an order whereby allowing my amendment application, Milord. The time frame was given 3 weeks, Milord. It was expired yesterday, Milord. I am seeking for extension for 2 weeks.
Why you are not carried out the amendment?
Milord, the client is out.
Who is for the other side?
Milord. Milord, this is a stage prior to issuance of the writ of summons. Milord.
Nobody is there.
Nobody is there. Milord.
And again it will be. How much time you require?
2 weeks, Milord.
Let it be mentioned to be mentioned on 12th, 11th.
My lord, may I have your lordship's leave, my lord, to mention one, my lord, matter, my lord, virtually, my lord.
Yes.
my lord, your lordship was pleased to, my lord, transfer, my lord, a non-commercial suit to the commercial division, my lord. My lord, I was seeking, my lord, a week's extension, my lord, to carry out, my lord, the procedure for getting it transferred to the commercial division, my lord.
So it is already transferred.
Your lordship had directed, my lord, to get it transferred
Hmm.
pursuant to your lordship's order. However, my lord, necessary steps could not be taken within the time period, my lord. I was only seeking, my lord, a week's extension to carry out the necessary, my
So
lord,
matter is
steps.
matter is listed.
No, my lord. The matter is not listed, my lord. I am praying that your lordship, if permits, my lord, to keep it as to be mentioned, my lord.
What is the matter? Where is the list?
My lord, the matter is not in the list, my lord. We are mentioning it, my lord. It's not in the list, my lord. I have served, my lord, Mr.
15th April
Polito
to be
Sinha, the
mentioned.
advocate on record for the state, my lord.
15th April has to be mentioned.
Lord, may I have your lordship's kind leave to
Grateful.
mention one matter, my lord? Lord, item numbers 94 to 96 of your lordship's daily list. My
Your Lordship, I'm appearing for the defendant in this matter.
lord, GA1 is my main interlocutory application, my lord. The interim order is expiring on.
In which 94?
Yes.
94 interim
Order
GA1,
is-
yes.
Order is expiring on 31st of March, my lord. I'm mentioning upon notice.
What?
The interim order is expiring on 31st of March, my lord.
1st of March. Let it tomorrow is to be mentioned extension of interim.
But there are certain, the other two GAs, my lord, I'll seek extension of time to file my pleadings.
And what about the other? With regard to the extension of time, I am fixing tomorrow as to be
Yes,
mentioned. Regarding other, you mentioned next week.
My lord, since they are appearing together, my lord, all three of them are appearing together, my lord. If they come under the heading to be mentioned, my lord, I will seek some extension, my lord.
This court is not having much time to all this.
Very well, very well. Very well.
The extension of time I will take.
Very well,
With
very
regard to the other, I will see.
Very well.
My lord's leave, my lord, for extension of the interim order, my lord, it's appearing in item number 71 and 72, my lord. Today's list, my lord. GA number 1 of 2022, my lord. Only praying for extension of interim order, my lord. The interim order, my lord, is due to expire, my lord, on 31st of March, my lord.
Oh, no. Take tomorrow as to be mentioned. Inform the other. If the other side will not come, then I will not accept.
I'll inform, my lord. I'll inform the other side. Grateful.
Yes, next.
No.
Yes. Have you gone through?
Lordship, we have.
What is the subject?
Lordship, the direction that was passed by your lordship was also to submit whether the amount that has been transmitted from the fixed deposit amount, whether that is still lying in the savings account or not. Lordship will kindly come to page number 11.
Yes.
Of the application that they have filed yesterday. Page number 11.
Yes.
Clause B, my lord, lordship's order.
Yes.
If the said fixed deposit is credited with the holders, give the details in which account it is credited and whether the said amount was remaining in the account till 21st April 2017. This is the date of death of the testator. My lord now kindly comes to page number 7. They have communicated that. This is the communication of the learned advocate.
Yes.
But last but one paragraph, that is paragraph number 2. They have asked for those details also from the bank. My learned friend has asked for it.
Which one?
Well,
Yes, same thing. Yes, yes.
Yes. Account details, not in exact words of my lord's order, but still they have asked for it.
Yes.
But that answer has not come from the bank. The bank's answer.
This is a which bank?
State Bank.
State Bank.
Well, that is at page number 33.
Yes.
But amount credited in respect of one FD to the account of Mr. Pradut Kumar Dotto. Lordship has got it?
Yes, yes.
But kindly see the next paragraph. One fixed deposit they could not provide. That is around 5 lakhs and odd.
Yes.
But what about whether the said amount is still lying in the account, or the testator encashed the amount or took back the amount from that account? There is no information.
Yes.
So the information given by the bank is incomplete. Regarding the mutual funds also, whether the same are in the account or not, well, that ought to have been provided by the state bank, and that could have been duly considered by your lordship if that portion of the order regarding the the statement of account could have been provided by the bank.
Where is the that mutual fund?
But mutual fund informations that, but it starts from page number
40.
lordship,
38.
lordship. But it should be 30, my lord. It's also at 28. But they say that some of the amounts, those have been, transmitted to this very savings account.
Yes.
Savings account of State Bank of the deceased.
The amounts are still there.
Malad, in page number 30, Millard. No, not 30. This doesn't have any page number.
Which one?
HDFC mutual.
But HDFC mutual funds gives an information which says that some amount is still remaining in that account. Malad, it is perhaps page number 37.
Yes, 37 mutual funds. Yeah.
Yes. Available balance, they show some amount.
Percent इतना further.
It has been transferred from large cap to switch over long term. Amount. This was the amount that was transferred.
But page 39 also shows that amounts have been transferred to other mutual funds of the same HDFC mutual fund, but other schemes. Page 39, the last portion.
Yes.
Other statement. 2024. It has been reinvested.
Page 43 shows reinvestment has been done. Page 43.
The investment, 23,000.
Page 43, Millard, last portion. Total IDCW reinvested.
23,500.
Lordship.
Yes.
So the informations that have been received, Millard, these are incomplete informations.
Yes.
Lordship, according to your direction, PGI.
First of all, you say to this court has not directed you to produce the document. If you could have been received the document, you directly produce this. You cannot interpret by way of an affidavit. First thing, you have not produced the original.
Yes, it is with me.
It is with you. What the court direction?
Not there was.
You are a very smart guy.
Lordship, kindly.
Court has issued the direction to the concerned authority.
My submission.
The court is asking something, you are submitting before that.
I have only communicated.
You have communicated. If you receive the document, what is your duty?
It was not written. What is the document? It was the envelope only. I have annexed the envelope.
How you open the envelope if you receive that?
It is not stated that it is with regard to this court, it was sent to me. There was no communication to that effect.
You have opened the document, you have interpreted the document and filed a separate affidavit without the leave of the court.
Look, after opening the envelope, I found that the documents are there. Prior to that, I had no knowledge.
So if you open, if you have no knowledge, have you informed this court? Till now you have not filed the original.
It is here, madam.
So
It is already here.
who has called for the document? Who has called for the document?
Your Lordship has
Then you will keep the document with you.
It is not stated in the cover.
I don't know if whatever it may be, either it may be anything. If you received, if you found that it is connected with this court and the court has called the record document, what is your duty of the advocate?
I'm submitting this.
I will not hear you call Mr. Chaudhary. Your attitude is not good.
I'm extremely sorry.
Sorry,
apologize.
I will not hear you call Mr. Chaudhary. Let Mr. Chaudhary explain this.
Sorry, my lord.
Sorry, not. I will take appropriate action.
I'm apologizing, my lord. Unqualified apology. If I have
The court has called the document. You have interpreted the document. You open the document.
Sorry, my lord. I could not understand what is inside this document.
If you, okay, I believe if you have communicated, the bank or authority has given the document to you and you open that and you found that this is a case. You have started all the affidavit interpreting and keeping the original with you.
I have filed.
What is the duty of the advocate?
Document. I have brought this document to submit before your lordship.
When the court has given the,
it was scheduled to be taken up on 19th, my lord. That's why I was waiting, because I could not have interfered into your lordship's regular business.
this is the attitude. Since beginning, you are doing like this only.
I'm failing to
The
understand.
court is going to settle the matters. You are making the complicated the matters. Day and day, day by day. Initially, you are agreed for the auditor. This court has appointed the auditor. Immediately after the appointment of auditor, you filed an application for discharge of the auditor. Auditor has filed the report. You have filed the objection to the auditor. When court has passed an order calling for the report, you have taken all the document and you have interpreted the document in your own way, keeping the original with you. This is the attitude of the advocate who is appearing before the court representing the parties.
They were also directed to serve. Have they served?
They served, they not served. That
They have also received. They have submitted before your lordship the last occasion. But they are not submitting. But I am submitting, my lord. I have brought my original. If your lordship kindly allows me, I can submit this here and now.
You are not mentioned in the affidavit. Okay, I will accept. Have you mentioned the affidavit? The State Bank of India has not given the account with regard to the amount which has been received by the State Bank of India from the mutual fund.
I have only communicated this through this affidavit, my lord. I have not interpreted.
Court has not directed you to communicate.
Then I'm. Let me.
Once it has been taken on record, yesterday's order, how you can take back this?
Then your lordship may take this original also. If your lordship so pleases, I have brought it.
कल के एक ओरिजिनल अच्छे तो HDFC कल का ओरिजिनल एक HDFC आया. HDFC has given the directly to the court yesterday.
I have written that here also, that they said that they will submit before your lordship.
How you got this?
They came to my office. They came to my office. They did not found the matter in the list. They came to ask me. I went to inquire into their office whether they have filed or not. And by that, I got a number of one of the officers. The officer called me. She came to my office to know whether why the matter is not in the list. I said that the determination has changed and we have mentioned the matter will be tomorrow. But they said that they had a discussion with the legal department, and there the legal department, after discussion, they said that we are handing up one copy to you. We will submit another copy if possible on our part before the court also. This is the HDFC matter. The others have directly sent through these envelopes. I have not, your lordship kindly takes my letter. Your lordship, if there is anything amiss, then your lordship certainly can castigate me. But I apologize for that, man. I tender my unqualified apologies.
So and so suffering for the
Your,
plaintiff, so and so suffering for the defendant. Full stop. By an order dated, by an order dated 8 February 2024, this court has directed the manager, State Bank of India, Juhu Tara branch, Mumbai, to furnish the following details. Record this. Page 4. The order was duly communicated by the learned advocates appearing for the parties to the State Bank of India, Juhu Tara branch. Though the bank has submitted some document, but has not submitted the report with respect of clause within bracket small b, whether the said fixed deposit is not submitted the report with respect of the b, clause b, whether the amount is still was still remain in the account of the testator till 21st April 2017. Unless and until the report is not received from the bank, it is not possible for this court to proceed the matter further. Accordingly, the manager, State Bank of India, Juhu Tara branch, Mumbai, is directed to submit a specific report to the effect that if the fixed deposit is credited to the holders, give the details in which account it was credited and whether the said amount was remain in the account of the testator till 21st of April 2017. 2017. Let the report be filed by the manager, State Bank of India, Juhu Tara branch, Mumbai, within 2 weeks.
My lord, lordship would kindly indicate, my lord, let them give the entire statement of accounts for 2000, but that will clarify the mutual fund also.
Within 2 weeks. It is further make it clear that the manager, State Bank of India, Juhu Tara branch, is directed to submit the statement of account of the testator, P.K. Datta alias Pradyut Kumar Datta.
May I make one submission, my lord?
Yes.
Previously, I saw
I didn't want anything document from you. Pradyut Kumar Datta, if he will say. It is further directed to the state manager, State Bank of India, Juhu Tara branch, Mumbai, to submit the statement of account of each and every account of the deceased Pradyut Kumar Datta. When he died?
But 2000, he died on
till 21st of April, till he died on 21st April, na?
Lordship, 2017.
Till the account is closed. It is still the account is there?
Still active.
Yes,
Activate.
No. Those accounts are closed. All closed.
No,
all transferred to the executrix account. All money transferred to each and every.
Till the date when the amount was transferred in the name of executrix, namely
Sonali Datta.
Sonali
Datta.
Datta.
DUTTA.
Sonali Datta. Let the same be filed before this court on or before.
The account number of the executrix also.
On or before.
All accounts bulletin.
On or before. Today we are on 21st. On or before 9th of April 2024.
My lord, will on the last occasion, lordship was pleased to direct, my lord, some interim amount to be, my lord.
Yes, what about the amount?
My lord, they had admitted in their, my lord, notes, it was 30 lakhs they admitted.
Yes.
Initially, the executive was not agreeable to pay anything, but since I have insisted that it has fallen from the your lordship, she has agreed to defray 10 lakhs, 5 lakhs to each of the 5 lakhs each to the to both the legatee.
No, you have not been allowed to use the account till the disposal of suit.
No. If she has agreed to allow defraying of 10 lakhs, 5 lakhs each to each of the legatee.
I have directed you to take instruction how much amount can be released in favor of the petitioner hearing. Because as per your admitted case, 30 lakhs rupees is there for both.
Yes.
Correct. It is
Okay.
admitted.
Yes.
It is an admitted case.
Yes.
And they have made some allegation against you.
Not-
With regard to, I don't want to disturb that. Only with regard to this is admitted case. It is the admitted. It is to be divided amongst both of you.
Not-
With regard to the other claim, when the
But
court is to be.
that is long back, and that was in terms of the settlement, my lord, not only for giving.
Because as per your account today, 50 lakhs is there.
Their settlement, or your lordship passes an order.
57
that
lakhs
was
are
As per your account, 57 lakh is lying in the
yes,
account.
my lord.
You are telling that the 57 that some is to be deducted from the expenditure is to be
Lordship,
deducted.
lordship.
So you are agreed for the 30 lakhs. So I am directing you to release the 10 lakhs in favor of the.
My lord, only for them, not for me also.
Not you will not allow.
What's my fault, my lord?
Your fault I will come at the time of final judgment. It will come.
Your lordship directs, then I have.
That's why again you are telling the yesterday what the court has directed you.
I have taken.
You are not understanding the court language.
I have taken instruction.
Yes.
She has said that 5 lakhs each can be different.
Where is your client?
Client is in London.
but internet transfers can be done.
Foolish, huh?
Internet transfers can easily be
No,
done.
there is no scope of internet transfer. She has to pay by check.
The executrix, though as on date, an amount of rupees 57,29,527 is lying in the account of the executrix, which was transferred from the account of the testator after the death of the testator in terms of the probate granted by this court. Now the executrix submitted only an amount of rupees 30,22,121 is to be divided amongst the testatrix and the petitioner. Your client is.
Lord, kindly record, this was my submission on that very day.
That I am recording.
Not of today, because thereafter a lot of expenses have come into action. My lord.
To the. Divided into two parts, into two share, full stop. As the executives admitted the share of the petitioner, half share of the petitioner out of the amount of rupees 30,22,121, and as such, for the interim measure, the executrix is directed to transfer an amount of rupees 10 lakhs in the account of the petitioner, namely.
My lord, purely this is the particulars, my lord. It's in a rough paper, my lord. Kindly ignore the other side of the page.
To transfer in the name of.
My lord, kindly record two predicament. One is she has to send a check, and that check will not be honored by State Bank unless your lordship directs.
Which check?
If she has to pay, the executive has to pay, my lord. In that event, she can pay only by check. She has the only avenue to pay by check.
I am recording the number and all. You can transfer the amount.
She doesn't have a scope in that bank account. She does not have a net banking account or anything like that. She only pays by check, nothing else, my lord. All right from the beginning, she has paid only by check. The bank is only having the facility.
In the foreign country, there is no transaction.
In India, my lord. This is State Bank of India.
RTGS can
She's-
definitely be
she's-
done.
Even for council also, she sends check for payment.
Okay, bacha.
As the executive admitted the half share of the petitioner of amount which is 2700, and as such for the interim measure, the executive
Transactions are only by check, nothing else in that.
10 lakhs out of rupees 33 lakhs, out of rupees 30 lakhs, out of rupees 30, 22, 121.92 in the name of the petitioner Pyali Datta, P-I-A-L-I, Pyali Datta, Normand, N-O-R-M-A-N-D. See there, Normand,
Lordship can give it to the court officer, my lord, that
by transferring the amount in the State Bank of India. This. Yeah. Let the amount be transferred in the account of the petitioner within how much time?
My lord, the time that will 15 days minimum would be required for bringing, but the check will be given to. I will give your lordship.
I am passing an order for transfer. Either you give the check or whatever it
I will
may be.
give the check to the
Whatever it may, I am passing an order for transfer of the account.
Your
The court
lordship
is
kindly write it down.
what?
Otherwise, if I fail, then your lordship will hold me in contempt, my lord.
Yes.
Because that's
So that's why I'm saying within 2 weeks you have to transfer it.
I cannot transfer without check. I am expressing.
That's why I'm asking you to bring me, call Mr. Chaudhary here. Whenever our court is asking any question, I cannot say.
No, I'm saying, my lord, I will have to. Your two orders has to be given, my lord. One is that the bank has to honor the check because it is already closed.
Transfer the amount in the so and so within 2 weeks from date. Let the matter of what is the date given?
And kindly direct
Let
the
the
bank
matter.
also to
Let the matter
honor the
appear
check,
on
my lord. Otherwise, the check
9th April
the transfer will not take place, my lord.
but apart from this amount, she won't be able to transfer any. Kindly records that,
It's
my
made
lord,
clear that
in terms of the previous order.
only the testatrix will transfer the above amount mentioned above and shall not invest any further amount from the said account till further order.
I'm grateful, my lord. I'm deeply obliged.
Lordship is fixing the matter.
9th.
Your lordship, kindly do not take me amiss, my lord. I am not in any way trying to do anything against the order, my lord. I have only communicated and
Sir, you are the senior advocate. You know the court has passed an order. You received the document. You have tempered the document. You directly inform this court. This has been received by me. I am placing before the court. You have not placed that.
my lord, I was not sure what
The court cannot teach all the advocate here by sitting what is to be done.
the only predicament is that I was not aware what was there in.
That's why I'm telling you are the senior person.
The lordship, may I submit the originals or shall I keep it with me?
Yes, call the matter.
My lord, I am for the plaintiff, my lord.
Yes.
My lord would recall this is the matter where the department was directed to hand us over the colored photocopy of the subpoena documents. All the documents which were there, which have been produced by Tata Capital Finance Services Limited. It was the conveyance deed, my lord, which was supposed to be provided to us. Now, the defendant had undertaken that they will provide us with the colored photocopy, but we are told by them that they are not in a position because the department has informed them that the colored photocopy cannot be done.
Only jumbo photocopier machine
Yes.
installed in the department is
So,
like.
We can do one thing. My
task
advocate on
is-
record with my lord's officer, and there are many shops across the street. They're doing this color photocopy. It has to be taken outside the court premises. That is the thing.
Who will allow?
That is the thing. That
I
we are
would
before your
upon the
lordship. You have to take it
undertaking-
across the street.
Upon the undertaking given by the parties, if your lordship can pass an order or allows your lordship's officer to accompany, like has fallen from my learned friend, then it can be done mutually. Because it may be returned to the court also in the day's time.
No, along with my lord's officer,
Yes,
we
yes,
can
of
go.
course. I
Yes,
am saying that only.
because there is no color photocopier in the High Court. It can be bought by High Court. Requisition to PWD, it will come, I believe, for this matter.
And also, my lord will look into the penultimate paragraph of the order that was passed on the 19th of February. Your lordship had directed ECL Finance Limited, which is the other body which was the subpoena was issued in their favor also, to produce original deed of conveyance along with 3 sets of colored photocopy. We don't know whether upon subpoena they are there today or not.
Because today is the, I think, to be
No,
mentioned.
it was on 15th of March.
Hmm.
The court was not over. But we have sent them and in the Park Street address, and it was being delivered.
What has happened?
But it is
Somebody-
delivered. Thereafter,
Somebody
no,
was appearing for the ECL.
no, this Tata is appearing.
Lordship
For
appearing for
Tata.
Tata Capital Limited.
Tata Capital is appearing. They have given the original. Now they want back the original.
Yes,
Whatever.
Lordship.
Now for the
So
ECL,
they will bear the cost.
yes, they will bear the cost for
Lordship
photocopy.
direction
Tata
was given
company.
upon the defendants to bear the
Yeah.
cost.
They want. They want.
They are not interested party to the proceedings.
They are
only
interested in the
appearing at the
document.
instance of the
Lordship,
defendant.
there was a direction upon us, we provided.
They are interested in the document.
So and so appearing for the plaintiff, so and so appearing for the defendant. The matter is listed as to be mentioned on the joint prayer made by the counsel for the respective parties. Full list. By an order dated 19 February 2024, this court has directed the department to get 3 sets of color photocopy of Exhibit 10 within bracket all pages in connection with CS Com 206/2024 within bracket old CS 121/2020 and the department was directed to notify the cost for the purpose of getting the colored photocopy of Exhibit 10. Full stop. In compliance of the order passed by this court, the registrar original site has submitted a report wherein it reveals that the department is only having a jumbo photocopier machine. This, so, but it is inoperable since May 2021. And as such, the department is not in a position to provide the colored photocopy of the said document, that is the Exhibit 10. Footsteps of error. Counsel for all the parties submits that if the court will permit the parties to get the said exhibit Xerox from outside of the court, the parties shall bear the cost and will get it Xerox from the outside of the court. Colored Xerox of the said document from the outside of the court. This court considers submission made by the counsel for the respective parties. This court finds that the photocopy of the Exhibit 10 is necessary for the purpose of this case, and the Xerox photocopier is not available in this court, in the department of this court, and thus the assistant registrar of this court shall take the Exhibit 10 to the Exhibit 10 and get it Xerox from outside, and the parties to the suit shall bear the cost of the same. And after getting three sets, get the 3 sets of the Xerox. And the parties shall bear the cost of the set Xerox and the cost of the set Xerox. And after getting the Xerox, the original as well as the photocopy, colored photocopy of the document be kept with the record.
My lord, I believe
Let this exercise be completed by the assistant registrar of court within a
Lordship,
week.
one indulgence.
Within a week, but next week is the holiday.
can be
After the whole good
Within
Good
2
Friday.
weeks. Within 2 weeks.
2 weeks. 2 weeks.
Lordship, one
what is the
indulgence.
My lord, my submission was that because this is a necessary document which has to be provided to the parties first, and since my witness is in the box and he is to be examined on those documents, let the witness action be fixed after this, and let
That's why
a
I am fixing
time
only
be-
for this.
Yes,
court.
yes.
That's I am not fixing the witness action. I am fixing and let the document come.
This
It will be
exercise-
circulated amongst
exercise
all of you.
Very
Then the matter will.
No, no, we have to inform the ECL once again, I believe, because they are not coming.
But because the 15, what has happened to the 15 March?
The court was not there, Malad. The court was not there.
Vote was not there.
The by an order dated 19th February 2024, this court has directed ECL Finance Limited to produce original deed of conveyance dated 6 February 2018, along with 3 sets of colored photocopy of the said deed of conveyance. But out of which one set should be certified by the competent authority, and the ECL was directed to produce the same on 15 March 2024. But the said document has not been produced by the ECL. Accordingly, the ECL is further directed to produce the said document as directed by order dated 19th February 2024 before this court on 11th of April 2020. List the matter on 11th.
11th.
My lord, has to be mentioned.
As to
She was mentioning ECL. It's ECL
ECL
Finance
Finance
Limited. ECL Finance. Otherwise, the coal companies will come.
ECL
Mr.
Finance,
Bose will-
Yes, Mr. Bose will start.
ECL Finance Limited.
ECL Finance Limited. Oblige.
Grateful village.
Malad, the
11th, my lord, I'm
Oh,
told
11th, there can be a holiday, Malad. There's a
The 10th.
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 The 10th. 10th.
What is the 11th one? What is the good day for that?
No, 11th, I think the
Eid.
Idul Fitr. Maybe a Idul Fitr. Our client.
Next.
May please, my lordship, appearing for the respondent side, my lordship, will be undertaking wakalat and also will
Which
be
one?
filing item.
Item 2 already. Today I am passing the order, then you appear.
Yes, but
The
just now we come for
the application filed by the petitioner plaintiff is allowed, receiver is appointed for taking appropriate steps on behalf of the defendant number 1 to 5 to remove the word dispenser from the corporate name of the defendant number 2 and 5. The receiver shall be paid by the plaintiff. The receiver is directed to file the report by 7th May 2024.
If they want to give the opposition, let them give their opposition.
Yes, you are appearing?
yes, my
You
lordship.
file the wakalatnama?
No, my lordship, going to file. Today we will be filing the wakalat, my lordship.
So-and-so appearing for the plaintiff, so-and-so appearing for the defendant. Full stop. What is your good name, sir?
Jinesh.
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 From Chennai.
Yes.
From Chennai.
Yes, my
Give
lordship.
the name.
Yes, my lordship.
So-and-so appearing for the all defendants.
Yes.
Defendant 1 to 5.
Yes, my
Not
lordship.
6.
Yes.
So she will remember. Sip my mind also.
So-and-so appearing for the defendant number 1 to 5 and prays for leave to file wakalatnama. Such leave is granted. Full stop. Yes, you will file a
Yes.
affidavit.
Yes. We will be first undertaking the wakalat and I'll file
He's
the
not doing it. Good. I'm grateful, sir. Good.
very much obliged.
एक ट्रैक्टर दिए थे डिस्पोजल नहीं बोला
Lordship, I'm appearing for the plaintiff. Defendants were supposed to continue their arguments today. It was fixed for argument.
Yes.
Lordship, I will not be in a position, Lordship. I have written to them yesterday also. The exhibits, the documents,
Message.
the exhibits, documents could not be reconciled, Lordship. I'll
You will
have
remember
to take
last
some
occasion,
time.
my learned friend was pointing at a date which he
Yes,
thought was
yes,
May.
true.
But from the documents from
Yes,
the exhibit, it transpired that it is March. I
Yes,
believe.
agreed, agreed. These documents could not be, I have to reconcile all of them, but it could not be done, Lordship.
So what can be done?
Some more time is required, Lordship. I'll get those exhibits reconciled. So
A commercial matter, it is fixed in the morning, Lordship.
97 matter.
no, I had started my arguments. There is no, I was ready with the facts, but since I cannot
Okay,
collate
Ajay.
with the documents,
Lordship, another date is already scheduled for
When?
hearing. 25th, date.
Yes, 5th April is already there.
5th April. Yes, 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 yes.
So and so appearing for the plaintiff, so and so appearing for the defendant.
Order in naam
Counsel for the defendant due to his personal reason and personal ground placed for an accommodation. Accordingly, the case is adjourned. It is fine from the order dated 6th March 2024. The matter is already fixed on 5th April 2024. 5th April. Leave the matter on 5th April. Come on that day.
Yes, yes.
Is for leave to file wakalatnama on behalf of the defendant number 125.
I'm told, my lord, the last order he did not carry the name, so it can be.
Yes, Paritosh, Shina, Priyankar.
Only one name was the rest of the names were
The
not.
plaintiff. No, your name, 6th March.
So Shah's name is recorded.
Yes. Paritosh Shina, Priyankar Shah, Pratyajit Sarkar, Arindam Mandal, Mukherjee.
I'm sorry, my lord.
All are there. Only plaintiff name is one, she is alone.
Yes,
Yes. Yes,
Lord, I
that
was on the
particular matter.
midst of my submissions on the last time. Lord, I'll finish it today.
Yes.
Lord, Lord, I was in the process of dealing with Mr. Rai's submission. Lord, just to Lord, summarize, Mr. Sengupta will correct me if I am wrong. What Mr. Rai has primarily submitted, his main submission was Lord that on section 15 of the Commercial Courts Act. Lord, he said, Lord, yesterday, just to Lord, so that we don't miss anything, I have Lord reviewed his submission on YouTube when he what is submitted on 6th of February. So Lord, now we have this advantage. So what he has said is that since 15 subsection 3 says that steps which were not taken are to be taken, and he said that since the suit was filed at the stage of filing of written statement, so Lord, he was not obliged to Lord comply with the requirement of Lord 15.3. He was not required to file the list of documents, affidavit, statement of truth, and affidavit under Order 11, Rule 1, Sub Rule 4. Lord, this was his first submission. I'll counter one by one. Lord, apropos to this, he relied on the Delhi High Court judgment. Second, he said that the word shall used in 15.3 may not be read as mandatory because no consequence is provided in the statute. So it is directory. For that, he relied on 2018 9 SCC 472. His third submission was that as per Rule 28 of Chapter 16 of the original side rules, the draft decree ought to have been produced before your lordships by the department. So the department should have placed it. Rule 28
Yes, yes.
Then he relied on Rule 5 of the Practice and Procedure. And Lord, he said that it is the department which ought to have Lord identified the suits and transferred it. And he said that since there was no direction to amend the plaint while transferring the suit from the original side to the commercial division, he was under no obligation to amend the plaint. Lord, this was precisely his submissions, Lord. Now, to deal with that, if my Lord kindly takes, Lord, section 15 of the Act.
Yes.
Lord,
shortly, my lord, just come back.
15.1, Lord, it applies that it says all suits and applications, including application under Arbitration and Conciliation Act, relating to commercial dispute of a specified value pending in High Court, where commercial division has been constituted, shall be transferred to the commercial court. So it is applicable to High Court. 15.2 applies to, Lord, the other courts. Lord, in both the sections it said shall be transferred. So the transfer, according to me, is automatic. The moment we have a commercial division in High Court, after promulgation of this Act, the pending suits will be transferred. Then 15.3, where any suit or application, including an application under the Arbitration and Conciliation Act 1996, relating to a commercial dispute of specified value, shall stand transferred to commercial division of commercial court under subsection 1 or 2, the provisions of this Act shall apply to those procedures that were not complete at the time of transfer. But it speaks about the procedure, not about the stages of the suit. Mr. Rai submitted that since, showing page 78, that since the suit was transferred at the stage of filing of written statement, he submitted that since he has already filed the suit, the plaint, without the list of documents,
That is,
statement of
see,
truth.
it is admitted, case is transferred.
Yes.
Only the case is that they have not complied with the other provisions.
Yes. Now, whether that is required or not.
That is required or not.
Yes.
So need not required to again go and
No,
go
no,
and-
I am not. No.
Correct. That
Yes.
since beginning, this court is asking the same thing, whether this can be done or not.
Lord, it cannot be done,
That's
and
why
this
you
is
show me
required.
why
Yes.
yes.
This is required because, my Lord, it speaks that the procedure has to be followed.
Correct.
Lord, I will, to answer this, I'll rely on this division bench judgment. My Lord has this division bench judgment. We have handed over on the last day.
Which
APO
one?
53, my Lord, Resmi Metallics. Kindly have a look at it.
Yes.
Lord, kindly allow me to place this, my Lord.
You already placed it.
Just one portion.
Kindly come to page 3,
Yes.
paragraph 2.
Yes, absolutely.
Correct.
Page 3, the fact emerging.
Correct.
Now, my Lord, I would say the facts of the present case is almost similar to that case. Why I say this? Kindly allow me to place this paragraph of the fact, page 3. The facts emerging from the pleading and the record of the court is that the coordinate bench presided over by one of us, Showman Sinje, by an order dated 25th February 19, directed that suit to be renumbered as a commercial suit, and the appellant, defendant, was directed to file written statement within 3 weeks from date. So, my Lord, here also the plaint was filed and direction filed written statement. On and from 25th February 19, the suit can only be heard by the learned single judge having the determination, that is to say, to try the suit as a commercial suit. A separate list of commercial suit is required to be published, and the suit is required to be heard following the procedure under Commercial Court Act. Once a suit is directed to be heard as a commercial suit, the procedure prescribed under Commercial Courts Act is required to be followed. It involves filing of statement of truth, discovery of
Yes, this
an
is
inspection.
the main crux.
So what Mr. Rai is saying, that since the suit was transferred after the suit, means the plaint was obviously was filed.
Correct.
After the filing of the plaint, so he need not have filed the statement of truth, list of documents, because that is to be filed along with the plaint. Lord, but the statute says the procedure has to be followed. Whatever was not done ought to have been done, which has not been done admittedly in this case. This is to answer his submissions. Then he said, Lord, that since no consequence is provided, Lord, in the statute,
yes,
then it should be read as the shall should not be considered, Lord, to be mandatory. Lord, kindly take order 11, Lord, which has been amended for the Commercial Courts Act.
yes.
Lord, order 11, rule 1, sub rule 5,
Yes.
Lord, Order 11, Rule 2, Lord, directs the party plaintiff to file the list of documents. 3, it says that he will file a declaration on oath, that is the statement of truth. Then 4, he will file the affidavit. Then 5, the plaintiff shall not be allowed to rely on documents which were in the plaintiff's power, possession, control, and custody, and not disclosed along with the plaintiff or within the extended period set out above. 7, except by leave of the court, and such leave shall be granted only upon the plaintiff establishing reasonable cause for non-disclosure.
That is a disclosure of the document.
So, if the plaintiff doesn't do it, then the consequence is he will not be allowed to do it unless the court further allows him. So, what Mr. Rai has said, there is no consequence provided. So, the section 15(3) should not be read as mandatory.
With regard to the 11(2), what
My
we
lord.
rely upon, that is with regard to the additional document.
Yes.
Here it is not
2,
the
3,
case.
4.
Ah,
2, 3, 4.
Here it is not
Lord,
that.
here in this case, neither the statement of truth, nor the list of documents, nor the affidavit in terms of 11(1)(4) has been complied with. The suit was heard, although in commercial division, but none of the proceedings were procedures were complied. Now, this is to answer his query. Then he made an alternative submission that your lordships have the power, when your lordships put a specific question to him, that how can the court at this stage do this? He said under 152. Lord, we have answered that 152 doesn't apply. 153 also does not apply. Now, he said that he was under no requirement to file the amendment plan. Lord, his submission is contrary to his own statement in the application. Why I say so? If he was not required to file the application for amendment of plaint, today kindly see what he is saying. He has now filed an application. The suit was transferred, blood on 14th November 2017, and he has filed this application, blood on 2023 July. So after 6 years, he comes up and says,
Transfer on?
suit was transferred on 14th November 2017. Page number 78.
And application filed on?
Blood application filed on July 19th July 2023. It was affirmed, filed on 23rd July.
Yes.
So, my lord, he was sleeping over his right, if at all there is any right, to file the amendment or seek the amendment for 6 long years. Lord, he submitted that your lordship's decree will not be, my lord, executable if my lord does not interfere at this stage. My lord, our litigant who does not follow the procedures of law, he did not file the statement of truth, affidavit, list of documents. He did not comply with 15(3). He did not amend the plaint. He said that it was the court which should have directed him to amend. Lord, his submissions and statements are completely contrary. He put it on the court. He said that it is the court's duty to inform him or direct him to file it. It was the registry's duty to direct him to file the amendment. But at the same time, in the application, he says that I have made a mistake. It was my mistake that I did not file it. Kindly allow me to file it now. So, Lord, absolutely, Lord, contradictory submissions made. Lord, I would say it's a very desperate attempt on the part of the plaintiff. To Lord, somehow, now at this stage, they realized that what they have done, they would not be able to put the decree into execution in future. That is why they are not. Lord, I'll just give you, Lordship, an illustration, Lord, subject to Lordship's correction. Lord, suppose I have a claim against the proprietor of a proprietorship concern. Lord, I file a suit against the proprietorship firm. I repeat, against the proprietorship firm. The proprietor comes up, he files the written statement. He contested the suit. Then I got a decree from your Lordship's court. After I got the decree, I realized that I cannot execute it because against the proprietorship concern, I could not have filed the suit. Then I comes up to court and say, my lord, the proprietor was there. He has filed the written statement. Kindly allow me to amend the cause title of the plaint post decree so that the decree binds the proprietor. Lord, that is not permissible. Lord, I will rely on a Madras High Court judgment. But I'll give you, Lordship, the copy. It's here with me. Lord, same same thing happened there. What happened, my lord, a decree was passed against the defendant number 1 and 2 in the suit. No prayer was made against the defendant number 3. Then after the decree was passed, an amendment of the decree was sought for. That was allowed ex parte. The third defendant then comes up, files an application under Order 9 Rule 13 that you have allowed it ex parte and all that. That was allowed. The plaintiff challenged both the order. The Madras High Court, my lord, it is reported in 1996. My lord, I'll give you lordship the citation.
1996? Yeah.
No, no.
Or
It is
Madras Law
all
Journal?
India High Court cases.
Madras Law Journal?
All India High Court cases, my lord.
Yeah, High Court case.
এক্ষুনি প্রিন্ট করিয়ে এনে দিয়ে দাও সফট কপিটা দাও জজ সাহেবকে কাইন্ডলি গিভ মি আ সেকেন্ড
All India High Court cases, Madras.
yes 1996
Page
3100 iPad dena sir kindly give me a second I'll just give you a lot of the iPad ऐसे कर देता मैं कि no time ही दे ওটা दे but I'll just place the facts first para 1 2. The plaintiff in West number so has preferred these two civil revision petitions. CRP number so is against the order dated 19 July 1995 allowing IA 1186 1995 in the said suit filed by third defendant for setting aside the ex parte order dated 30th June 1994 passed in IA number so in the said suit. IA number 16239 1994 was filed by the plaintiff for amendment of plaint. The decree in the above said suit was passed on 29th of November 1991. But the said IA for amendment of plaint is only in the year 1994. So amendment after the decree. The decree dated 29 November 91 was only against the first defendant and the second defendant, who are the educational authorities of the state, and the decree declared that the state of date of birth of the plaintiff, who is the employee in the above said railway, is 15th May 1993. IA 12242 of 1994 sought to amend the decree so as to incorporate the relief for directing the third defendant to correct the said date of birth in its service record. After that suit is decreed, amendment filed for taking further relief. CRP number so is against the order dated, kindly take the para 4. Even after hearing the argument of the learned counsel of the petitioner, I am quite convinced that there is absolutely no case for any interference under 115 of the Civil Procedure Code. As already mentioned in the original decree dated 29 November 91 was only against the first defendant and the second defendant. In fact, since there was no prayer at all in the original plaint against the third defendant remained ex parte in the suit. No doubt it appears that the plaintiff pending the suit also filed IA number so seeking temporary injunction relating to the above said date of birth even against the third defendant, but the plaintiff withdrew IA presumably on the footing that the said relief cannot be granted against the third defendant of the civil court, and the plaintiff should approach the Central Administrative Tribunal. That is why after withdrawing the said IA, the plaintiff took up action with the Central Administrative Tribunal seeking the relief, but there he failed. Then he took up the matter to the Supreme Court, and there also he failed. It is only after the Supreme Court order the above IA has been filed. But it is very much curious to note that even though the relief is sought for in the said IA against the third defendant, no notice of the third defendant is served. Without notice, the third defendant, the trial court allowed. The trial court also failed to note that originally the plaintiff did not ask any relief against the third defendant, and if after the decree is passed, a fresh relief is sought for against the third defendant, it is really strange that the court had not at all applied his mind. Now, kindly pause here for a moment. Here in this case, reliefs were claimed in the suit. I am not saying that reliefs were not claimed against me, but the ratio that is decided is that post decree you cannot seek for an amendment. What you have not sought
That is the problem. Either you or Mr. This is not the case of amendment of the decree.
Amendment of the plaint. Amendment of the plaint.
Correct.
That cannot be done.
That's why I'm asking
Yes.
here with regard to amendment. Here, that's why
Here,
at the time of argument, Mr. Ray also stated that
Yes.
it is not with correction or
Absolutely.
amendment of the here
Absolutely.
only with regard
Absolutely.
the plaintiff has not complied with
Yes.
the 15.3.
Absolutely.
15.3. Whether after the judgment that can be done.
It cannot be done.
With regard to
Cannot
the
be done.
judgment, because
It cannot
this
be
is
done.
not the case,
But
that because the judgment was passed in the commercial division.
Absolutely.
But that cannot be, decree cannot be drawn.
Yes.
Because it does not,
Absolutely.
the plaintiff does not speaks about the all document which is required for the
My lord.
drawing of the decree.
Absolutely. Lord, I would not prolong it, Lord. I only say that today, post decree stage, I will just not to sum up. What we have submitted is that after the judgment is delivered, your lordship has signed, this court has become functus officio.
Correct.
So your lordships can only correct if there is any arithmetical error under 152 in the decree. That is not the case. That is not even his case. So that cannot be allowed. Second, amendment under 153 could only be done up to the pendency of the suit. After disposal, it cannot be done. So today, this court, firstly, does not have the power or jurisdiction to entertain this application. Second, a person who was sleeping over his right for 6 years, by putting the blame on the court, he cannot get away with this. He has put all the blames on the court, on the registry, on the department, on the master, on the registrar, everybody, while making submissions through his learned counsel. But in the application, he says, it was my mistake, I could not do it.
That he didn't want to put on record.
So, Lord, in this sort of a situation, your lordship would not interfere, and Lord, no order should be passed in this application. And Lord, he says that he was not directed. Lord, it was his duty to amend the plaint. I have shown order 6 rule 18. So Lord, no direction was necessary. And Lord, the judgments that he has cited, I have dealt with that. So Lord, I would conclude by saying that no case has been made out at this stage for the amendment or allowing him to amend the plaint. That's it.
Thank you. Take care. Yes, what is your submission?
Largely, Millard has been argued by Mr.
What do you
Mitro.
want to add further?
I just
You are
want
for
to
the
defend number 1, 2, and 3.
different member?
Mr. Mitra and Mr. Chakraborty argued
You are for the?
defend number 1, 2, 3.
Yes.
Millard, I will not repeat the points that I've already argued. My points are largely on those lines only. 2, 3 things that I want to point out.
What? Yeah, that's what you want.
The first point is that if Lordship kindly takes up the application that has been filed, paragraph 8, once.
Yes.
But I'm reading that paragraph. However, upon the judgment and decree dated 15th May being passed by this Honorable Court in the instant suit at the time of drawing of the decree, it transpired that though the orders dated such and such directed the intent suit to be placed under the heading commercial division and the formal transfer having been effected, the requisite amendment to the division in the cause title of the suit and the other relevant places and the portions of pleading pertinent to the proceeding of the instant suit has not been laid down by this Honorable Court in terms of the sections and such. Now, Millard, here there is direct statement that this Honorable Court did not direct us to make the transfer. That is why we could not do it. That's the insinuation. Thereafter, the next paragraph. So it's a blame on the court. Now, when it's a blame on the court by a party which has from 2017 till 2023, for 6 years, continued with this suit. I'll show orders annexed in the petition how he continued with the trial. Now, the next paragraph, paragraph 9, the petitioner states that such latches on the part of the petitioner as plaintiff were inadvertent and caused due to oversight which petitioner seeks condonation. And paragraph 10, last sentence, any accidental omission in causing the requisite amendment to the cause title of the instant suit should not be denied the petitioner to the fruits of the decree which may have obtained upon trial. Now, in light of these pleadings, I'll show your lordship the prayers once of this application. The first prayer A, there are two primary prayers. Prayer A, judgment and decree and such be drawn up by the concerned department of this Honorable Court as a decree passed. Now, there is no document, not even a single document by which he can show that department is not being able to draw up. There is no report, nothing from the department, no note, nothing. So it's just a statement and prayers in terms of that. There is no annexure in the application itself. The second prayer is that, the alternative, an order allowing the petitioner to cause necessary amendment to the cause papers. Cause papers are part of the plaint. So basically he seeks an amendment of plaint Now, my lord, I'm asking this question to myself, whether the amended plaint, the plaint with proposed amendments, has been disclosed in the application or not. Lordship knows in the original side, or even in the other proceedings. But if one lord seeks amendment of plaint, the plaint with proposed amendments has to be annexed with the schedule that these are the changes I want to make. Where is that plaint, my lord? Where is that plaint with proposed amendment? There is none, nothing. Nothing has been annexed. The plaint that has been annexed here, Lordship would kindly come to page 10 of the plaint of the application. Here, he annexed a plaint saying this is the plaint I filed. In the plaint, it is still showing original side. There is no mention of the commercial division. In the application which he has filed, he mentioned commercial division. So he on his own changed the cost settle of the proceeding and filed an application. Now Lordship would kindly come to some of the documents that he has annexed. He basically annexed all the order sheets to show from the time it was converted into a commercial suit in 2017 November. From that day onwards, that is at page 78. Lordship would find that he has annexed all the orders that have been passed from 14th November 2017 onwards at page 78. So amended plaint is not there. He has annexed it. No schedule is provided that these are the amendments I'm carrying out. I want to carry out. Or there is no pleading regarding amendment. And that reading part, that is also missing. Now, Lordship would kindly come to page 78 of the application. That is the date on which the suit was held to be a commercial. The dispute involved was held to be a commercial dispute. The second paragraph of the order. From this page 78.
Yeah, that's correct.
Yes, Lordship has seen it. Now, from this page 78 till page 117, all other orders are annexed, one after the other. In none of those orders, Lordship would find the mentioning of commercial division. Why this happened? Because of this mistake. Lordship checks all. I have gone through all the orders from page 78 to page 117.
Yes.
Page 117 is also an order passing the original division, regular division, not a commercial division. That all these while, that the applicant today and the plaintiff all along continued this as if, despite there being a transfer, as if this is a commercial division, and that is how we proceeded with the trial, the entire trial. Lordship would find the orders passed in the trial division during the trial stage, page 120 onwards. That all these orders are in the commercial division.
Commercial division.
So regular division. All these orders, Lordship would can take it from me. I'll show you, Lordship, the first order. Thereafter, at page 144. Yes, that's the only order. One order that was mistakenly passed in the commercial division. I don't know what mistake is on their part. They did not disclose it in the court.
This is a very unfortunate statement. He appeared at every instance in commercial division.
I am not a plaintiff.
And he's saying all
I was not the plaintiff,
You have some duty as an officer of the
absolutely
court.
not. I am a plaintiff. I'm the defendant.
You are an officer of the court.
So are you. What have you done then?
Why are you personalizing things? Whoever may have appeared.
So this page 125, first order passed in the commercial division, page 125. Apart from that, all orders passed in the regular division. Kindly come to then page 144. That's the second order in the commercial division. That was passed by your Lordship.
125.
125 and thereafter 144. That was passed by your Lordship. Now, after page 144, at page 145, there is another order passed in the original division, regular division. So there was confusion all along, and plaintiff being the plaintiff had the carriage of the proceeding. Now, having that right, it was duty on the plaintiff to continue it with bona fide. And one day it is in the commercial division, next day it is in the regular division. Why? Because the plaintiff did not take the steps which were required to be taken at the time and amendment of plaint. If that had been done at that stage, today all this confusion would not have arisen. Pursuant to this 145, 146 onwards, the rest of the orders are passed in the commercial division. That is when, even then, these orders are passed in 2022, August. And 1 year he continued like that. It was duty upon the plaintiff to tell your Lordship that this is a problem, or take out an application for amendment of plaint at that stage when the plaint was alive and Lordship had the jurisdiction or to cure the defect. Today, when the defects are non-curable at all and court has become functions official, I will not repeat that submission made by my learned seniors arguing for other defendants. Today, court cannot. It is just bypassing a stage which could not have been bypassed. And one last thing, It's just a Lordship sees the prayers once again. It's just a sympathy, my lord. He seeks a sympathy from the court that look, there is a decree in my favor, but I can't execute it. Now, my lord, Lordship has seen the resume judgment. Court has said that I was the, my lord, beneficiary of that judgment before your lordship. I went in the appeal court and said that I had been bona fide all through, but same mistake was there. I missed. There was a mistake. I could not get it amended. Decree passed in the appeal court. Court said it was your duty. I was the beneficiary there. As a lawyer, I was the beneficiary of that judgment. But court said no. You go back. Trial will again take place. That's the course. It will reopen. We'll all get chance to contest. There is no other mechanism known in law by which this can be cured. There is no precedence anywhere.
See, if the amendment is allowed,
yes,
naturally, once amendment is allowed, it is the rule of law. The amendment
It will be served.
is
Yes.
to be served.
Yes.
Then, if it is served, then you have a right to file the amendment, additional whatever it may be. That is subsequent.
So, here, but that question would not come here because the proposed amendment are not indicated. Those are my submissions. I will not repeat. Grateful.
Two things, I would like to clarify, certain prejudicial submissions are being attempted to make that it's a slur on the court. But it's not a slur on the court. Or else we wouldn't have the Latin term or the Latin phrase where no one should suffer for an act of the court. That is what I have been trying to bring out before this honorable court. For that purpose, I had placed a judgment of the Delhi High Court, which is the most important judgment in my case, which I believe, I don't think it has been dealt with by my learned friend.
Yes, he is arguing.
And if he has dealt with it, that clearly, says that it is something which has to be done after the transfer.
Correct.
In your lordship's court, it can be evident, and it is evident, that after the plaint was filed, written statements filed, it is thereafter, that it was transferred. Now, I have shown your lordship the practice rules also. It is your lordship's rules, not my rules. Your lordship's court has furnished it and framed it, which also clarifies there is a department who will do it. But let me not go into this first. Let us try and understand where I am coming from. Today, your lordship is well aware. I don't think your lordship, this happened before your lordship. The decree was sent to your lordship where there was a difficulty saying that it is not there in the plaint. That is why, your lordship remembers that we were as a matter of fact guided, if I may say so, that you file an appropriate application. And that is why we came before your lordship in this application. What is it that we are asking for? Your lordship sees the judgment. Judgment only says the department to draw up a decree in terms of this judgment. And the judgment clearly says commercial division. At the time, when this decree is sent to be drawn up, there is no reason for the plaint to be amended. That is a procedural flaw. Your lordship, could have asked me then before passing the decree. At the time when the decree is being drawn up, it is not for the court to look into it. Now, why do I say that it might be a mistake of the court?
No. If we go by your submission.
Okay,
the court has passed an order because the matter was listed in the commercial division. The matter was heard in the commercial division. And as per the cause title, the court has passed the judgment on the commercial division.
Absolutely.
Correct. And finally, it was directed to drop the decree. When
the judgment.
When the decree was going to be drawn, so it is found that the court has passed the judgment under the commercial division. But the plaint which reflects, because in the plaint, the judgment, when the judgment is decree is to be drawn, that is in terms of the cause title and concise statement, and the prayer of the plaint is to be taken into consideration, and the operative portion of the order,
judgment
is to be recorded in the decree.
Absolutely.
So these are the three things is to be taken from the plaint. That is the cause title. Second is the concise statement. Third is the prayer portion.
Prayer portion.
So once the department was going to drawn up the cost title. So it is found that the court has passed an order judgment under the commercial division, but the the cost title is not under commercial division. So what the decree department will do?
Well, the decree department can do only two things. Well, that is why 153 is there. That is why 153 is there. It is a defect. I can submit with humility, and doesn't take me amiss.
No.
Kindly looks at section 15.4 for once. May I just show you, Lordship? This needs to be, because this is a question which might arise later also. So, I would like to kindly sees 15.4 once more,
Yes.
Sorry, 15.3,
Correct.
Where any suit or application, including application or arbitration relating to commercial dispute or specified value shall stand transferred to the commercial division or commercial court under subsection 1 or subsection 2. This Justice Munshi did. The provisions of this act shall apply to those procedures that were not completed at the time of transfer. What are these procedures? Let me ask myself this question. What can be a procedure? Procedure is how to file a plaint?
No.
I do not know, dear Lordship. The procedure has to be from that time.
Plaint is already there.
So, the procedure for filing a plaint is over? It is over.
Correct.
Now, your Lordships have a right, which is during this practice rules and also the management hearing. Your Lordships can direct that amend the plaint.
That after not this case, earlier also I find there are several orders. In 2017, there are several orders like this.
In my case, it was not directed.
Several orders. No, not without direction. There are several orders. When I find it was difficulty in the record, then when I started transferring the matter, then I
your Lordship
directing to comply with.
Absolutely,
correct. Now,
because may I say this also?
With regard to this, so if it is which was not done, so commercial court act, because as per CPC, what was required you have done.
Yes.
Correct. The plaintiff has done all the things at the time of filing on the suit. Yes, plaint, consent statement,
everything. Verification, no statement of truth or anything of that.
Now, once it has come to the commercial division, the very first thing is the statement of truth.
There where I am trying to kindly appreciate. Statement of truth, has been made a part of the CPC for this act at the time when the plaint is filed. So, if your Lordship, with humility.
No.
After I file the
court, there is no humility.
No. But I kindly, because because this is a statement which might also look into what we are doing in this moment, whether there can be a mistake, because this is a new procedure. There's no dispute about that. Statement of truth, has been incorporated in the process of filing of the plaint. Not otherwise. So, the procedure, let us say it's a commercial suit at the very beginning. It becomes...
There will be no problem.
No, there is a problem. I'm saying this. Then the statement of truth, that is the plaint. Now, in my case, there is already a plaint.
Correct.
Statement of truth, we are going back. We are going back,
Correct.
Then, we have to go forward. Now, there is no direction from your Lordship. Unless there is a direction, 15.3 will apply. Because, my learned friend's written statement also does not have a statement of truth. No one has it. So, there has to be a direction. Now, kindly also appreciates. This is not a regular, we are, as a matter of fact, we are not even supposed to file an application before a Lordship for transferring to the commercial division. That is not allowed by this act.
Because it is prior to the act.
No. May I make this point? Not that, I'm talking as general submission. 15, with humility, again I say, does not require an application to file before the single bench for transfer to the commercial division. Kindly see, 15.
Read it.
5.
15.1 first. How it is to be transferred?
Yes,
pending cases, court can so moto.
Your Lordship will. That is what I'm saying. I cannot make an application before your Lordship.
That's a pending cases. Once the court, because once the new act has come,
Yes, my lord.
When the new act has come, the ordinary division ceased to be having jurisdiction, and court finds that it is a commercial division.
Your lordship will
automatic.
So, my lord, this is whose, my lord, with humility again, whose action is it? It is the court's action.
Yeah, the court has passed an order for transfer.
Yes, now, my lord, yes, there I'm coming from there. So, my lord, I cannot approach your lordship for orders. Your lordship or the department will see that I have to do something. Now, your lordship kindly sees 15.3. Because procedure, your lordship, is something which your lordships are laying down.
Yes.
And that is explained by 15.4.
Hmm.
It says the commercial division, commercial court, as the case may be, may hold case management.
Case management subsequent.
Hearings in respect of such transfer suit or application in order to prescribe new timelines or issue
Correct.
or issue such further directions
Correct.
as may be necessary. So that direction never came.
That is the up to court. If see what's happened.
That is up to court.
Up to court when? If
Once you
the
have
case
transferred.
is transferred.
Yes.
If the case is transferred, defendant never appeared.
No, my lord.
No, I am telling
Oh,
with
I'm
regard
sorry,
to the issuance of, if the court find no, defendant is not appearing, the case has been transferred, a fresh writ of summons is to be issued, or the written statement is not filed, their application is pending, then fresh guidelines is to be issued. With regard to the parties appeared, written statement filed and transfer. So then the fresh, if the case management has not been done, then the case management is to be with regard to the issue, file, discordant inspection, issue, and
so when it is post transfer, whatever is being done.
Correct.
Then, my lord.
So now it has to now, as per your argument, now we have to see before transferring of the case, what was the stage of the suit? What was the stage of the suit? So kindly come to the page 78. Page 78 is the 14 November 2017.
Yes,
2017.
Yes, my lord.
14 November 2017. Prior to that, what was the stage of the suit? Written
I filed my suit. Written statement.
Defendant number entered appearance long time back, and other defendants have also filed their written statement.
Yes.
Defendant
number one has not yet filed.
Written statement.
So many defendants have filed, one has not filed. And then commercial. So, my lord, it was the court which decided that I do not need to file a statement of truth. That direction is not there, my lord. That is why I'm saying, my lord. In that matter, my lord, Justice Shen's judgment.
Interpret this order again.
Yes, yes.
Come to that.
Subject to payment of cost, defendant is granted leave.
It is a new direction. 15.3.
Yes. Sorry, my lord.
Defendant number one has not given not filed the written statement.
Yes.
Transferred to the suit.
Yes.
The guidelines has been given subject to payment. Then he has been given liberty to file subject to payment.
Yes. No problem.
No problem.
He has not been asked to also give a statement of truth.
No. At that point, written statement was there. Now,
no, my lord.
Now I cannot guide at this stage. You cannot catch hold of it. I don't know.
No, my lord. Written statement one is not there. Rest are filed.
Written statement after the transfer, written statement was filed. One. Subsequently, prior to that, all the defendants are filed. Correct. So
we are at the stage of written statement.
So at the time of transfer of the case, in terms of what you are pointing out, when we come to the
15.3, my lord.
15.3.
My lord.
Four. Kindly come 4.
No, first is 3, my lord.
3 is with regard to the to complete all the transfer.
No, my lord.
Kindly. When
the last sentence.
Yes.
Last line. Provisions of this act shall apply to those procedures that were not complete
at the time of transfer.
My procedure for filing of plaint was complete.
But in the commercial division, what was the procedure?
My lord, it is not, my lord, humility, my lord. The act only comes into play after that procedure, not before that. Even if I come into the act, prior things, whichever has been done, my lord, the act is incorporated only after that procedure. Kindly reads, my lord, with humility, my lord, again. The provisions of this act, there's the Commercial Code Act, shall apply to those procedures that were not completed at the time of transfer. So the procedural requirements under the Commercial Codes Act will be only after, because the act is incorporated in a transferred suit only after the procedures which have been completed.
So you mean to say, yeah, if it has been transferred under 15 and you already filed the suit, so further requirement is not necessary.
Not for the statement of truth. Yes, your lordship can direct me because, my lord,
leave aside
I'll point out, no, my lord, I'll point out because 15.4 becomes important there. Why your lordship can direct me? Because why is a statement of truth required? Well, let us go to the jurisprudence. Let us not make statements, my lord, which are not related to jurisprudence. The jurisprudence is, my lord, it tantamounts to a speedy disposal. Why? Because when a statement of truth, my lord, the petitioner or the plaintiff or the defendant is held to its statements by an affidavit. The perjury thing comes in because we were earlier on the verification. And also, my lord, that's why the discovery and inspection, that becomes important. That is under 5 heads then. That is why the statement of truth was required.
That is the case management.
Well, this is also case management. Statement of truth, if required, is a case management. I'll point out why, my lord. Case managements are required in case of transfer suits in a similar, in one kind of a manner, and in case of, my lord, regular commercial suits in a different manner.
Kindly come to case management. Kindly come to the order 15A.
Yes, my lord.
15A.
My lord.
The case management hearing, after hearing the parties, once it is found that the issue of the said fact of law is required and to be tried, case management will come from the date of issue.
But kindly see 15.4 once.
15.4, yes, okay. Now you are stating that case management will come at the time of issuance.
No, Malat, Malat is looking at order 15, right, Malat?
Order 15, capital A.
Let's just give some. Now, in any case management, Malat, kindly sees, Malat, order 15A. 1, 2, 3, 4, 5, 6, Malat. Prior to the framing of issues here and decide in pending applications, or B, direct parties to file compilation documents or pleadings relevant and necessary for framing issues.
Correct.
Extend or shorten the time for compliance with any practice.
Correct.
Direction or court order if it finds sufficient reason to do so. So, Malat, this is the practice. This is the practice which your lordship can direct, and why? 15.4 clarifies it.
So you mean to say if the court has not directed and the parties are not complied with, the party cannot suffer?
But there is no compliance required. That is what I'm saying. With humility, I say 15.3.
So if it is how the plaint be treated as a commercial if it is not been done? If it is okay, leave aside
our case, Malat.
No, leave aside the statement of truth and document. Leave aside. I accept your submission with regard to your file the document at the at the time of filing of suit in the ordinance division. What about the amendment? Because now we have the problem not with regard to the statement of truth because they are not challenged at the time of cross examination. That is not the question here.
But if I'm over with that, then I will come to this.
Because with regard to the statement of list of down, they have not traced this point.
Only I will make one small submission. If your lordship, I'll give a hypothetical situation. There is no time fixed for your lordships to decide whether this is a commercial division or not. Let us say, Malat, at the very end, your lordship feels that this is a commercial division. Well, let us say, Malat, my learned friends witness, if they were being cross-examined and they are finished and we are starting our arguments. And your lordship finds it is required to be transferred. Malat, what does this court do? That is an answer which we need to give. Because what is sauce for the goose is sauce for the gander. And that is why 15.3.
Yes,
that is why 15.3. That you do not need to go back. Because, Malat, kindly sees, this is a procedural matter. But, Malat, there are substantive rights which has already accrued in my favor, which my learned friends are now trying to overcome by making whatever statements they want to make. Even my learned friend, one of my learned friends who appeared, has said something that there was no reason. They have also made their applications in commercial division. Okay. So, Malat, that is what I'm trying to point out. And that is the distinction, Malat, in Reshmi Metallics. In Reshmi Metallics, there was a direction. that you amend. देखिए
This means the said application.
Come on, I made a mistake.
Man.
I made a mistake.
Renumbering was there.
It was renumbered. Kindly see page 3. Come on, kindly see page 3, Malad, just from the top, Malad. The applicant was prevented from filing the reinstatement due to non-furnishing of the commercial suit number. Malad, kindly sees the case, what has happened. Commercial suit number not given. They wanted, no, Malad, kindly. They wanted the suit number so that they can file the written statement.
Where it is?
Case number. Kindly see Malad 2 at the end. The plea that the appellant was prevented from filing the written statement due to non-furnishing of commercial suit number is a clear afterthought, as the department was directed to renumber the suit, and it was the duty of the applicant record to approach the department and file the written statement with the renumber after it was transferred to the commercial division. Right. The facts emerging from the pleading and the record of the court is the coordinate bench presided over by whatever, when order dated 25th February 2019 directed the suit to be renumbered as a commercial suit, and the appellant director was directed to file written statement within 3 weeks on that date. On and from 25th February 2019, the suit can only be heard by the learned single judge having the determination, is to say, to try the suit as a commercial suit. A separate list of commercial suit is required to be published. Suit is required to be heard following the procedure under the commercial suit. Once a suit is directed to be heard as a commercial suit, procedure prescribed under the commercial suit is required to be followed. I'm very grateful, Malad. This is in my favor.
Why?
Once it is declared as a commercial suit, the Commercial Court Act comes into play. Correct. And then, Malad, it is required to be followed. So it is required to be followed. And as I gave the example, Malad, there is no timeline. What happens to the evidence? Let me just try and understand that. Nothing can be done. Therefore, 15.3 was there. This was a case where 15.3 was not considered. Other than that, let us just proceed, Malad. It involves filing a statement of truth discovery inspection within the stipulated time in the manner as prescribed under the relevant rules. Is not in this way the consequence of the suit being transferred as commercial. It was not heard as a commercial suit following the prescribed procedures. Lansing has proceeded to hear a suit as an ordinary suit and not as a commercial suit. Here it was heard as a commercial suit. Evidence was in the commercial suit manner by an affidavit of evidence. Each and every Malad, the consideration, Your Lordship, I've also annexed the judgment where this was a specific consideration that in a commercial suit, whether an affidavit of evidence can be filed, as well, this was the first matter where it was done. So it was always being heard on the commercial suit. Here it was not. Therefore, it was not. Admittedly, although on the date fixed, the court was wearing two hats. The procedure is different and distinct. Admittedly, consequent upon the suit being transferred to a commercial division, statement of truth and alpha were not complied with. Suit was not ready to be heard as a commercial suit in that regard. Now, Malad, the first finding is that it was not heard on the commercial suit. I am distinguishing that. This matter was heard on the commercial bench without requiring any amendment to be done. There was no direction.
That is the question now.
So now, Malad, where is, Malad, with humility I submit, where is that duty cast upon a litigant? In the act, where is the duty?
Who has engaged the lawyer?
No, Malad. Malad, it has to be through the act, because act is making changes. Malad, let us see the commercial court sector. We need. Excuse me. Let us see, my lord, where the amendments have taken place. CPC.
Yes.
My lord, kindly see.
Which provision?
I thought you were.
Order 4, order. My lord, if he doesn't want me to submit, but I'll leave it to your lordship.
Who?
But I think he is objecting that I'm.
That I want. My wishes will not stop you.
No, then kindly don't make statements.
Thought we are in reply.
So don't make that statement, please.
Yes, yes.
If your lordship feels that, my lord, I will then stop.
Yes, yes, yes.
Yes, my lord. Kindly seize, my lord, the schedule to the Commercial Codes Act.
Which schedule?
My lord, there is the main schedule just after paragraph section 23, my lord.
Yes, schedule. Yes.
And first, my lord, there are amendments to section 16. That is about filing an affidavit, my lord. Then, my lord, kindly finds that there are costs, my lord, then goes to amendment of first schedule. And this is schedule 4. In the same schedule, my lord, I don't know how to. This is the 4, my lord.
Amendment of first
schedule.
Yes.
In the first schedule to the court, in the order 5, rule 1, in sub rule 1 for the second provision, the following proviso shall be substituted. Namely, where the defendant fails to file the retention 120 days. Then comes to order 6, B, my lord, 4B.
Yes.
In order 6, after rule 3, the following rule shall be inserted, namely, in a commercial dispute, where forms of pleadings have been prescribed under the High Court rules of practice direction, where the purpose of such commercial pleadings shall be in such form. After Rule 15, the following rule shall be inserted, namely, but at verification of pleading, notwithstanding the content Rule 15, every pleading in the commercial shall be verified when affidavit and mail are prescribed. Then, my lord, now, my lord, kindly sees order 11.
Discovery.
That just gives you a moment.
बोलते क्यों नहीं फिर?
15. Sorry. 15.
How much time you take? Other matters, 15 minutes you've taken more.
Well, may I come back then? Because I have to distinguish the judgments on it.
But in reply, I believe you will argue on law, but if he re-argues the matter again, we would have made all these points if he has argued on day 1.
Yes.
But I'll not make further arguments. I'll not distinguish his case.
Distinguish the judgment.
It's not up to your lordships to allow him or not.
So appearing for the plaintiff, so appearing
Always such a attempt is taken.
Counsel for the defendant has concluded his argument. Full stop. Counsel for the plaintiff has started giving reply, but due to paucity of time, reply could not be completed. Fix.
But not the 27th and 28th, kindly, my lord.
11th April.
Very good.
But 11th April, I believe there will be a holiday. Your lordship's calendar is not marked with a red ink on for 11.
Yes.
12th
দেখো
April.
একটা ছুটি মার্ক
12th
করা
April.
আছে।
My calendar is a special calendar.
ওটা বলা নেই এখনো। ওতে
Even I am carrying two calendars. In one it is marked with red and in other one it is not. Not if it's a proposed holiday. If the Eid is declared on that, then the High Court will notify.
Then 12.
Perhaps not.
12.
12.
grateful man.
Or not on 15th because 12th.
Okay, key on 15.
Yeah, 15th.
15th April.
তুই বল না, বল যশোরকে বল।
Yes, call.
কি হয়েছে 15 তোর কি অসুবিধা? গাঙ্গাই বিশ্বকাল
শুধু দুপুর বেলা সকাল
গান গাইবে কোর্টে আসবে।
Call the matter. Item number 30.
My lord, in this matter, my lord, I've made an application, my lord. The defendant number 3.
Who is for the plaintiff?
My lord,
Why it is fixed today?
my lord, for the witness action, but my lord, all the other parties have, there were a lot of, it's a partition suit, my lord. In this matter, all other parties have amicably settled and we can, except for there's a difference, there's a difference of opinion.
My lord, I'm for the
defendant number,
You are appearing for.
defendant number 1 APC and
Okay, you are appearing for defendant number 1. It is a today's witness. Your witness is present.
Your Lordship, it's for defendant number 1 witness today. The plaintiff's witness was closed abruptly, Your Lordship. I'll just say what is.
Evidence of plaintiff witness is
Yeah,
processed.
my lord, I have filed an application under Order 14 Rule 2 to set out a preliminary issue only with regard to the share of defendant number 663. He has given a deed of relinquishment. She has registered. There's a registered deed of relinquishment while which she has relinquished her share. Now this is up to the court to decide whether she is entitled to her share or not. If this issue is decided, there were a lot of issues in the suit.
One, the case is at the stage of one as the case of the stage. This court is not going to here and there. You want to adduce the evidence, other I am closing the case today.
The witness is there.
Bring the witness.
My lord, kindly.
If you're relying upon the relinquished date, you exhibit it. The today's case would have a witness action.
Witness is there.
Bring the witness.
If the preliminary issue be
I am not going to fix any preliminary issue. When the case is fixed today for witness action, you are relying upon the relinquished date. You exhibit it. I will decide in the final judgment. I know how the practice is doing with the advocates. On the last occasion, they are delaying. I have closed their evidence. If you want to adduce the evidence, you adduce. Otherwise, I am closing it.
my lord, because there were a lot of issues.
Might be. That will be decided. Lot of issues. That's why it is to be decided after the evidence.
Issues have been amicably settled between other 7 defendants.
Come with the settlement date. Come with the settlement date. On the basis of the submission, the court cannot pass an order for settlement.
Lawyers of all the other parties, my lord.
That this court will not believe the lawyer's statement. Come with the settlement date.
That is, my lord, Order 14 Rule to set up this application.
I am not fixing any issues. If you wanted the matter has been settled between the parties, come with the settlement date. If you want the issue is to be decided, come with an evidence. Simple thing.
My lord,
First.
मेरे आस्ते आस्ते आपको इंग्लिश आता है?
नहीं,
मैं
इस मुकदमे में
गवाही के तौर पर
गवाही के तौर पर
जो कुछ बोलूंगा
जो कुछ बोलूंगा
सच बोलूंगा,
सच बोलूंगा,
सच के सिवाय
झूठ नहीं बोलूंगा,
झूठ नहीं बोलूंगा
और कुछ नहीं छुपाऊंगा।
का नाम
सरस्वती चंद बजाज।
He is on behalf of which
सरस्वती
defendant?
चंद बजाज।
1 APC and he is himself
SARAS
Defendant number?
3A.
That's why I'm asking. He is appearing for. He is the defendant number 3.
CHAND
And he's appearing on behalf of 1 APC.
HAND
Take that. You take on evidence.
बजाज BAJAJ।
आपको पिताजी का नाम
लेट शिव रतन बजाज। शिव रतन बजाज SHEW।
Ratan Bajaj.
Ratan Bajaj. 54. मैं बिजनेस
एड्रेस बताइए।
6A बाल मुकुंद मक्कर रोड BALMUKUND मक्कर रोड कलकत्ता 7
কি প্রিন্ট এটা কি প্রিন্ট
Can you tell my lord as to who are you in this suit?
अब इस केस में इस तौर पे आपने केस को फाइल किया है इस केस में आप कौन
मेरे फादर मतलब मेरे फादर शिवरतन बजाज वो इस डिफेंडेंट नंबर 1 थे उनके एक्सपायर होने के बाद मैंने इसमें 3A के हिसाब से पार्टिसिपेट किया
My father, that is late Shiv Ratan Bajaj, was defendant number 1 in this case, and after his death, I am appearing as defendant. I have been substituted as a defendant
Substitute
in this case.
Can you tell my lord as to the other legal heirs of original defendant number 1 were also added in this suit?
जो और लीगल एयर है वो भी क्या इस यहाँ पर ऐड किया है इस केस में
नहीं उनको से बीना देवी बजाज मेरी मदर 2 सिस्टर
उनको ऐड किया गया
हाँ ऐड किया गया
yes the other legal heirs are also substituted for defendant number.
Can you tell my lord as to what are their numbers as defendant in the suit?
उनका नंबर क्या क्या है इस केस में
1A B and C
1A किसके लिए
1A बीना देवी बजाज
1A
बीना देवी बजाज 1B शर्मिला अग्रवाल शर्मिला अग्रवाल 1C श्वेता चितलांगिया CHITLANGIA CHITLAGINA
as you know the name SWETA Sweta Chitangal CHITLANGLA
Do you know defendant number 6 in the present suit?
वो मेरी आंटी है
she is my aunt.
Are you aware of any deed of relinquishment signed by defendant number 6?
yes
DD1. DD1.
Page number
Page number 241 to 240. 240.
Kindly 241 to 248
see this document and tell my lord as that whether it is a registered original deed of
you have produced the original you have
original produce.
produced it
What kindly tell my lord what is this document of?
क्या है
ये मेरी बुआ आंट का किया हुआ रिक्लूसमेंट डीड
this is the relinquishment deed of my aunt. Yes, next.
Can you produce the original of this document?
Yeah. Yes.
Don't say.
Yes.
When can you produce the original of this document?
प्रोड्यूस करेंगे कब तक में कर पाएंगे
मैं आज भी कर सकता हूँ, मैं आज भी कर सकता हूँ, लाया हूँ।
I have brought the deed.
इसके पास फाइल हमको देने दिए, दे दे।
Time if I can.
उनको नहीं मिलेगा सर, उसी के अंदर नहीं।
Is this the original deed of relinquishment you are talking about?
ओरिजिनल है
ओरिजिनल
deed of relinquishment.
मेरे पास ओरिजिनल भी है, इसकी नोट
Original. You
करवाया।
give the original.
इसमें है, मैं निकाल दूँ।
Give it to him. He will search.
ये ओरिजिनल सर।
पहले अपना डॉक्यूमेंट संभालिए। This is the original deed of relinquishment.
Kindly see this document and tell my lord, is it a registered original deed of relinquishment you are talking about?
क्या register किया गया है?
Yes.
Yes. This
Yes.
is the registered original deed of relinquishment.
How did you get this document?
आपको ये डॉक्यूमेंट कैसे मिला?
ये मेरे को मेरे फादर और ग्रैंडफादर की कित से मिला, उन्होंने दिया था।
This deed of relinquishment was given to handed over to me by my father and my grandfather.
Can you tell my lord as to when?
Yes.
Can you tell my lord as to when this deed of relinquishment was signed by defendant number 6?
Yes.
आंट के द्वारा कब ये साइन किया गया था? अपने यहाँ से
8 फरवरी 1983।
On 8 February 19.
More than 14 years old. Signature is there at page 4 of the registered deed of relinquishment.
कमल कुमार
Page 4.
पहले देखिए आप आपको देखने बोला।
कमल कुमार बनर्जी एडवोकेट और
First,
कमल कुमार बनर्जी एडवोकेट एंड फर्स्ट, सेकंड है मधुसूदन घोष।
मधुसूदन
घोष
who has signed the registered deed of relinquishment?
इसने साइन किया है ये deed of relinquishment.
मेरी आंट उषा खेमका।
My aunt Usha Khemka had signed this deed of relinquishment.
How did you came to know about the signature of Usha Khemka?
आपको कैसे पता चला कि उषा खेमका जी ने ही इसको साइन किया है?
उनके पुराने जो कागजात, चेक बुक या उनके और भी कागजात, डॉक्यूमेंट्स वगैरह जो पापा के पास में पहले रहते थे, उन्हीं के हिसाब से मेरे को पता चला कि उन्होंने किया।
I had seen the old documents that were with my father. In the documents, my aunt Usha Khemka had signed, and therefore I became sure that this is the signature of my aunt Usha Khemka.
Your Lordship, he has adduced that he has old checkbooks and signed papers of the defendant number 6. Kindly that.
I have seen what you have stated. Why you have recorded? I have seen the old document, that is checkbooks. और क्या क्या डॉक्यूमेंट देखे?
चेकबुक पे पहले पापा के पास में जो
चेकबुक और क्या डॉक्यूमेंट?
चेकबुक उनके पास पड़ा हुआ था, उसी में से उनमें साइन को लगा कि उन्हीं का ये साइन। और
Okay, I have seen the checkbook which was lying with my father, from in which the signature of Usha Khemka was there, and thus I can identify this is a signature of Usha Kemka. Yes, next.
Can you tell, my lord, are there any witnesses to this registered deed of relinquishment?
कोई witness है? Witness sign किया?
मधुसूदन घोष जो थे उनका एक तो मेरे पास वो
नहीं, उससे विटनेस का साइन है या नहीं है, वो पूछ रहे हैं आपका वकील।
विटनेस का तो कमल कुमार बनर्जी और मधुसूदन घोष।
Yes.
Yes.
Witnesses have signed the deed. One, namely Kamal Kumar
बनर्जी
and
एडवोकेट ना बनर्जी ना बनर्जी होने से
Banerjee advocate, and the second signature is of
मधुसूदन घोष।
Are you aware of the whereabouts of Kamal Kumar Banerjee advocate and Madhusudan Ghosh?
ये कहाँ रहते हैं, क्या करते हैं, आपको पता है?
जब ये रिक्वायरमेंट ये दो 9 नंबर प्यारी मोहन गार्डन लेन में एक जन रहते थे।
कौन?
मधुसूदन घोष।
Madhusudan Ghosh used to reside in
प्यारी मोहन गार्डन लेन 11 नंबर।
number 11 प्यारे सुदन
प्यारे
मोहन गार्डन लेन। और
मधुसूदन घोष एडवोकेट कलकत्ता।
इनका
कमल कुमार बनर्जी।
ठीक है, then yes, next.
Are you aware of any affidavit signed by Shri Madhusudan Ghosh?
Yes.
Where is that affidavit?
इसमें लगा हुआ
कहाँ लगा
है, इसमें लगा
अभी है आपके पास?
यहाँ पे नहीं दिया
एडवोकेट के पास।
I was with regard to the original deed of kindly that we master sex.
Yes, madam.
Lordship, I have not been served a copy. Your Lordship, I do have.
But judge's bureau of document is there.
They've only adduced a. Okay.
Judge's bureau of
Your
document is
Lordship,
fine.
I have some very strong.
If they are not engaging, what can be done?
Lordship, I will be getting somebody. Yesterday we were I was quite unwell. But I'm kind of preparing.
Exhibit, what is the exhibit last? This is the defendant first witness, na? Exhibit 1. Why? Cross में हुआ था. Exhibit 4. Yes, next.
With regard to the deed of relinquishment, kindly come to page 4. I would say the signature could be marked.
It is gone as a whole. As a whole total. If you want the signatures to be exhibited. Signature of Usha Kemka. Signature of Usha Kemka in the deed is marked exhibit 4/1. Signature of the witness, namely with Kamal Kumar Banerjee is marked as exhibit 4/2, and signature of another witness, namely Madhusudan Ghosh is marked as exhibit 4/3. Yes, next.
Can you tell, my lord, as to what was the age of defendant number 6 at the time of execution of this registered deed of relinquishment?
23 years.
How can you say so?
Birth certificate September 1960 birth.
उस टाइम में 23 कैसे था? At the time of
Birth
death,
certificate.
at the time of death,
Calcutta.
Usha Kemka was 23 years. Second answer, what is the second answer?
birth certificate है।
किसका?
Usha
As per the
Kemka.
birth answer of the second. As per the birth certificate of Usha Kemka, her date of birth is
September 1960.
September 1960. Yes, next.
Can you produce the birth certificate for this honorable court?
Yes.
When can you produce the birth certificate?
Next time में देगा.
The next time. Was there any affidavit signed by your grandfather with regard to that birth certificate?
Father, grandfather ने किया.
Yes.
Yes.
Can you produce that document?
Next.
On the next date of hearing. Was defendant number 6 married at the time of signing the registered deed of relinquishment?
Yes.
Whom was she married to?
Mr. Arun Kumar Khemka.
So as per your last answer, Mr. Khemka was 23 years of age and was well above the age of maturity while signing the registered deed of.
How we can say?
We agree.
How we can say? 68. Then?
Can I stop your mic? If there are any questions left, my lord, that is why I was saying, so as per order 14, the privilege issue is decided only with regard to her shares. The suit can be decided because then I don't have to throw for so many questions.
That's why I'm telling you. See, your case is depending upon this date, relinquish date, and this is the witness of 1 AP until 6. Correct. So is the defendant number 6? Defendant number?
1 A, B, C, and 3A.
No, he is
3A.
3A. 3A. How many defendants are there?
There are 7, 8.
They are not appearing.
My lord, they are advocates appearing.
You are appearing. And you are supporting the case of the plaintiff, correct? You are supporting the case of the plaintiff?
We are appearing for the defendant number 4.
Just a minute. You are supporting the case of the plaintiff? Yes. And you are appearing for the
Defendant number 6.
different numbers. You are contesting.
Yes.
You are challenging the date.
Your lordship, in fact, all in the WSs, the stance they're taking, as today it's admittedly they're saying that they're relying upon their the deed.
Whatever it may be, that is subsequent.
Yes.
So you are challenging, you are not accepting the date.
Not at all.
You are challenging and you are claiming your share over the property,
Very
correct?
much, Your
And what about the defendant number 4?
What has happened, the defendant number 4 advocate on record is expired, Mr.
Hmm.
Neil Mata. We have not taken instruction, my lord. We will take instruction in the meantime, my lord.
So what if it is that? So she has to, if your issue is also be framed, but see, if the preliminary issue is framed, that also cannot be decided on merit. It is to be on evidence because she is denying that. So no purpose should be served on the matter. Court case has to go on merit. So now you will adduce only one witness or other witnesses.
One witness, but my lord, if the preliminary issue is decided, then I will not ask so many
Sir,
questions. Because they were.
I am telling, that's why I am see, preliminary issue, only for the preliminary issue, the evidence cannot be taken into consideration. Evidence is to be taken into consideration as a whole, and at the time of judgment, then the preliminary issue is to be decided first, and if the preliminary issue is decided in your favor, the rest goes. Correct. So again, the evidence will come. So, and regarding preliminary issue, issue can be framed at any point of time, alter or deleted, whatever it may be. So now we have started the witness. Let you complete it. You want to adduce any further evidence other than this? No. Then you will adduce your evidence.
Your lordship, I would want to cross-examine
What?
on the.
Cross-examination will get chance. That you will adduce
Your lordship,
evidence.
I would request them to be called on stand, each of the, because now they have taken a stance. They're supporting.
What?
Your lordship, the reason I'm saying this, they're all in contempt. There are several other issues which needs to be taken care of.
That's why I'm telling.
Subsequent
That's why I'm
issues.
telling. That's why I am not framing at this stage. I am not framing any preliminary issue. Now his witness is going to be examined. They are relying upon this relinquished deed. Relinquished deed has come on record. Now, after their completion, you will get, because all the parties are, I don't know what, with regard to the defendant number 4, defendant number 5, and others are admitting the document. Though they have taken the stand in the written statement, now at this stage, let the cross examine what they cross examine. Only you will cross examine with regard to the document.
Your Lordship, there is also another issue. Defendant number 1 has in fact relinquished his share because there was a
Whatever it may be, whatever it may be. So you will take the cross examination. After your cross examination, if you wanted to adduce evidence, you adduce evidence, then the case will be decided on merit. There's no problem. Because what I have is a 1997 suit. I don't want to continue with this suit for the long period. So it is to be disposed of as early as possible. On the last occasion, that's why all the application I have not taken up for hearing. Let it be decided at the time of hearing of the main suit.
They are in contempt of the court. They have
Maybe
usurped my entire share. They admitted, somewhere they're admitting, somewhere they're saying.
So that's contempt will when come unless your share is decided.
Your Lordship, they've admittedly, defendant number 1 was the only one who was contesting, who was relying upon the said relinquishment, deed of relinquishment. Everyone else has said that deed of there is no deed of relinquishment, legally valid deed of relinquishment. And he himself has admitted 150. He's saying that I have share in my mother's share.
That cannot be said.
Now he cannot take a stance which is different than
that is a matter of argument. That you cannot say this is a contempt, they may be put in the jail. That is a matter of argument. It's a settled law. They cannot go beyond the pleadings. That will be taken at the time of hearing of the suit.
Your Lordship, that's true, but they are in contempt and they are going to sell off more properties. There's one very. Your Lordship, on the last occasion, I couldn't file my affidavit of service in CC 14 of 22.
You keep it. I am not taking. At the time of hearing, I will take it. So appearing on the plaintiff. So appearing for the defendant number. Defendant number 1AB, 1ABC, and 3A. Comma so appearing for the defendant number 4. So appearing for the defendant number 5, and the defendant number 6 is appearing in person. You are not the defendant number 6.
I'm not, and Your Lordship, every date it's written as advocate. I'm not an advocate. I come in.
Who are you?
I'm the daughter and the constituted attorney who has filed her wakalatnama in the matter.
Next time, I will not allow you.
Your Lordship, Your Lordship, I'm trying to get an advocate.
Yes, you bring the advocate.
Because I need an legal assistance now at this point.
You're not in person, and the private party cannot be given a constituted attorney.
Your Lordship, Order 3 rule Order 3.
But original said there is a separate. The lawyer is to be bring on record. You are not a person, and this court will not allow that. Yes, what is stated? Appearing, defendant number 6 is appearing through. What is your good name?
Neha Khemka. Your Lordship, and prior to this, it was written as advocate. I'm not an advocate.
Neha Khemka, who is the daughter of the defendant number 6, as constituted attorney or representative. Full stop. The defendant number, the constituted attorney / representative of the defendant number 6 submit that she will engage lawyer to defend the case of the defendant number 6 on the next date fix. Full stop. Today, the defendant number, and today the witness of the defendant number is present. Examination in chief started, and during his examination, one document is exhibited, being exhibit 4, 4A, 4/1, 4/2, and 4/3. Full stop. Counsel for the plaintiff, counsel for the defendant number 1, prays for time to conclude the evidence of the defendant number 1. Accordingly, chief of the defendant number 1 is deferred. This is the matter on. It is also fixed tomorrow. Let the matter appear on tomorrow.
Kindly given bring the documents,
It is 2 dates. You could have been bring the document. That is the problem. The word suit, that's why you fix them 2 matters. Where is the document? Tomorrow. And bring your advocate also tomorrow.
Your Lordship, I would need some time because I was not well. I was traveling because of some medical emergency. Can I be allowed this in April 2nd week? I've already spoken to Mr. Mitra. The person who I was supposed to engage. He would
Madam, this is 97 suit. I will not give more than 2 weeks. More than 2 weeks. I will not give more than 2 weeks.
2nd week of April, Your Lordship.
Let us see. Let the chief complete first.
Lordship.
Next.
Lordship, I am for the plaintiff. I am for the plaintiff. We are ready with our opposition, Lordship. There is a difficulties, Lordship, that we are still now affirm the opposition. If your Lordship allow us, then we serve a advance copy to the
You are appearing for whom?
Plaintiff, Lordship.
You have filed an application. Who has filed
No,
the application?
applicant.
J5?
I filed the application,
What is the
Lordship.
J5?
GA5, Lordship. I filed the application for
What is the
addition of
GA?
party.
Addition of party.
Party by the
Addition of party, why the affidavit and all these things?
Lordship.
Why the affidavit in opposition?
Lordship, your Lordship permits us to file.
Not permit, but you are not completed. Why? What
Lordship,
is the objection for addition of party?
Lordship, we have prepared our opposition, Lordship. Kindly give me. I'm
copy.
serving advance copy, Lordship.
Why you are not filing? What is the
Affirmation yet not.
Why?
Done. Lordship, client is suffering some medical emergency, Lordship.
Client is objecting for the addition. Client is not
Lordship,
filing
give me
affidavit.
one day time, Lordship. I will affirm and file before.
I am
the
fixing
department.
tomorrow, not today. Come tomorrow?
Lordship.
Not today. As per the prayer made by the counsel for the plaintiff, the case is adjourned. Let the matter appear tomorrow.
Lordship.
Lordship, I have served an advance copy.
Lordship, I received the advance copy. I may be allowed.
Let the file first affidavit. Come tomorrow, let the file the affidavit, then I will pass the direction. Get it affirmed today, you will affirm?
Lordship, yes, Lordship.
It will be done tomorrow.
Lordship, kindly keep this matter next week, then it is very well, Lordship, actually. To be very honest, Lordship.
Son suffering for the plaintiff, son suffering for the defendant, counsel for the plaintiff, press for a week time to file affidavit in opposition. In where the submission made by the counsel for the plaintiff, time to file affidavit in opposition is extended for a week, reply if any there to be filed within
a week, Lordship.
Within a week thereafter. List the matter on 16th April.
Lordship.
Next.
Lordship.
I appear for the plaintiff. Lordship will recollect, my lord, this is that matter. My lord, Mr. Gupta had appeared, Mr. Chayan Gupta on last occasion, my lord, he handed over, my lord,
yes.
a screenshot of, my lord, the website of the defendant, my lord, saying that, my lord, there's a disclaimer which has been given by the defendant, and my lord, I was asked to take instructions. My lord, I have taken instruction, my lord. The plaintiff is not agreeable. My lord, for the simple reason, Lordship, the dispute is with regard to the mark South Point. If my lord kindly sees their website, what they are saying, they are using Howrah South Point. My lord, South Point is the prominent and most essential feature, my lord, of the website domain name of my lord of the defendant. And it is in that backdrop, my lord, the same is not acceptable to the plaintiff. So now, if my lord kindly permits me, my lord, I may place the facts, my lord.
Yes. Where is Mr. Gupta?
In that event, my lord, password will be allowed.
Password then? That is the problem.
Lord, my learned friend is there, my lord. May I start?
Okay, okay, you take note.
Yes. My lord, this matter is coming up before my lord after exchange of affidavits. My lord, the mark concerned, my lord, is South Point. My lord, I am a school, my lord, of a global repute, my lord. Lord, I hold Guinness Book of World Record, my lord, for being the biggest school in the world, my lord, not just in state of West Bengal or India, my lord. My lord, I have disclosed the documents, my lord, to show, my lord, that I hold Guinness Book of World Record. Lord, I have been using the mark from the year, my lord, 1954.
Where do you mention?
My lord, if lordship comes to paragraph 5 at page 4, my lord, the plaintiff petitioner, my lord, or my predecessor in interest, my lord, have since the year 1954 been continuously, extensively and uninterruptedly been running educational institution under the name South Point School and South Point High School, my lord.
Just a minute. Yes, IP note कर लेना. Yes.
My lord. So, my lord, in paragraph 5, my lord, I have said, my lord, from the year 1954, my lord, in fact, the defendant also admits He admits in his affidavit, my lord, that I am a school of great repute and my mark is a well-known mark. My lord, basically, my lord, they have tried to, my lord, oppose my application, my lord, on 5 counts. My lord, the first point, my lord, was a preliminary objection raised by the defendant, my lord, with regard to maintainability of the suit. My lord, if I may just, my lord, try to cross that hurdle first, my lord.
When they have registered this?
No, they are not registered, my lord. What they said, my lord, I am a society, my lord. I am a society within the meaning of the West Bengal Societies Act. My lord, if lordship kindly takes the cause title once, my lord.
Yes, under the society. Yes.
So, my lord,
how in the suit?
because, my lord, they said because of the embargo under Section 19.
Right.
My lord, subject to correction, my lord, I am armed with a division bench judgment of our Honorable High Court. If lordship kindly takes Section 19 once, my lord, may I?
Justice Chakravarti.
No, my lord, Justice
Judgment.
Division Bench of Justice State, my lord.
Yes.
If my lord kindly takes Section 19 once, my lord. My lord, the language used, if lordship takes Section 19, every society may sue or may be sued. May, my lord, the expression used is may, my lord. It does not use the term shall, my lord. In the name of the president, the secretary, or any office bearer authorized by the governing body on this behalf, my lord. So, my lord, when I had tried to move this injunction at the initial stage, my lord, they had, my learned friend had taken the preliminary objection with regard to maintainability, my lord, because I have not made president a party or the secretary a party. And, my lord, to buttress, my lord, that submission, my lord, they had relied on a single judge, honorable single judge judgment reported in 2010, volume 3 CHN. They relied, my lord.
2000?
2010, volume 3 CHN, Calcutta 755. My lord, may I just hand over? But, my lord, in my respectful submission, my lord, this judgment possibly, my lord, is per incurium and cannot be looked into, my lord, for, my lord, it fails to consider a division bench judgment passed by this honorable court, my lord, reported in 2003, volume 3 CHN 583, my lord. This has not been considered. Now, if my lord kindly allows me to place this judgment, my lord. My lord, the question, my lord, will find at paragraph 2.1. Mr. Banerjee, appearing for the appellant, has raised two very interesting questions on which this appeal was admitted, which are set out as under. The suit having been filed by a society without being represented by the secretary of the society or any office bearer thereof authorized by the governing body, in view of the provisions contained in Section 19(1) of the West Bengal Societies Registration Act, the suit is not maintainable. My lord, identical, my lord, objection was raised, my lord. My lord, I am not troubling your lordship with any further, my lord, statements, my lord, in paragraph 2. If lordship straight away, my lord, comes to paragraph 7, page 2, my lord. So far as the first ground is concerned, admittedly, it appears that the suit was filed by Ramakrishna Mission. Section 19 of the West Bengal Societies Registration Act requires that the society may sue or may be sued in the name of the president, the secretary, or any office bearer authorized by the governing body, my lord. Then, my lord, if lordship kindly three lines from the bottom, my lord, at same paragraph, my lord. Yeah. Therefore, this shows that the suit was being filed and conducted by an office bearer authorized by the governing body, the secretary. So, Ramakrishna Mission, Asaram, Jalpaiguri was duly authorized to conduct the suit and or empowered to institute and continue with the suit by himself. Now, my lord, paragraph 8. Now we are faced with the question as to whether the suit could be treated to be in order because of the fact that the suit filed in the name of society and not in the name of the president or the secretary, my lord. Same, my lord, question. In order to examine the said question, it would be necessary to deal with the scheme of Section 19 of the 61 Act. The object and purpose of incorporating Sections 18 and 19 of the 61 Act is to enable the society to act through its office bearers or the governing body. It is a legal fiction that has been created so as to impede some person owing responsibilities for the society. It is a safeguard against the society to protect the interest of the society, or else no one would have been able to defend the society and anyone could have sued in the name of the society. Therefore, to protect the interest of the society, the authority has been restricted only to the governing body. Therefore, the question that has to be looked into is whether it is the governing body which is suing, or it is representing the society in the proceeding itself. The framing of Section 19 of the 1961 Act starts, now my lord will kindly mark this, starts with the expression may. The word may sometimes be interpreted as mandatory. Now it is to be looked into whether the word may used in this section is mandatory, my lord. Then, my lord, Mr. Banerjee relied on so-and-so decision. Now, my lord, paragraph 9. It appears that the said decision was rendered without examining the scheme and the scope and ambit of Section 19, for which Sections 18 and 19 were incorporated in the Act itself. If we examine the scheme of Section 19, it appears that the subsection 2 states that no suit or proceeding shall abate by reason or of any vacancy or change in the holder of the office of the President. The secretary or the office bearer authorized under subsection 1. Therefore, it was not the President or the secretary who were the real persons to continue or maintain the suit. It is the society which is interested in the suit, for whom the President or the Secretary was acting. The subsection 3 of Section 19 provides that every decree or order against the society in any suit or proceeding shall be executable against the property of the society and not against the person or the property of the President or the Secretary or any office bearer. Therefore, it is not, now my lord will kindly mark this, therefore it is not the President nor the Secretary in their individual capacities being sued. It is the society which is being sued through the governing body. In other words, the society is the principal and the governing body or the president, secretary, or authorized office bearers are the agents of or the attorneys of the society. There is a distinction between the principal and the agent. We cannot confuse the two. Therefore, we cannot, my lord will kindly mark this, therefore, we cannot interpret the word may in Section 19 to be a mandatory so as to preclude the society to sue in its own name. It can either sue in its own name or can nominate its president or secretary. So, my lord, thereafter, my lord, their lordships. So possibly, my lord, I am very well covered by this division bench judgment, my lord, where this honorable court has clearly held, my lord, that a suit filed simplicity by the society itself, my lord, is very much maintainable. My lord, that was the first preliminary objection which they had taken. Now, my lord, if lordship, my lord, another point what they have taken, my lord, this is the first, my lord, point of objection raised, my lord, by the defendant is the bar under Section 17. Possibly, my lord, I have been able to overcome that hurdle, my lord. My lord, second point, my lord, which has been taken by the defendant, my lord. Defendant states, my lord, that the name, my lord, my mark, is a generic word. So that is the point, my lord, what they are saying. It is a generic word, and hence, my lord, they are, my lord, entitled to use. Third point, my lord, what they have taken, my lord, they say that I fraudulently obtained leave under Section 12 capital A of the Commercial Codes Act. My lord, with greatest of respect, lordships, my lord, in fact, a mediation proceedings was, my lord, initiated, my lord, and non-starter report, my lord, will find appears at page 85, my lord. They initially, my lord, they sought time, my lord, before the mediation council, my lord. At page 85, my lord, sees, my lord.
Yes.
It's a non-starter report.
Non-issue.
So, my lord, statements have been made, my lord, which is, my lord, contrary to the facts. And, my lord, another point which they have raised, my lord, is that there is no similarity between my mark. My lord, lordship, my lord, the two marks which my lord is concerned today, my lord, is a South Point, my lord, I am South Point, and Howrah South Point. My lord, whether both are similar or not, lordships will have to, my lord, test that. And, my lord, another last point, my lord, what they have raised, my lord, is they state, my lord, that they are a charitable organization. And their existence, my lord, is surviving, my lord, on the basis of, my lord, donations which they receive, crores and crores of donations. My lord, exactly that is the point, my lord, which is, my lord, pinching, my lord, the plaintiff. My lord, plaintiff is before, my lord, because, my lord, the defendant using the name of the plaintiff, my lord, is raising crores and crores. My lord, I was not aware that they are raising crores. I knew, my lord, they were, my lord, receiving donations. Now, my lord, it's on an affidavit where they state, my lord, they are receiving crores and from people across the globe. So, my lord, they are saying that in as much as, my lord, they are doing a charitable business, my lord, their name should not be, my lord, they should be allowed. My lord, these are within substance of that. Now, my lord, if I may trouble your lordship with, my lord, the documents which the plaintiff intends to rely on. If Lordship turns to page 22, my lord, of my application, my lord, is printout of the Guinness Book of World Records 1984 edition. If Lordship kindly turns to page 23, Lordship will find school largest world. My lord, on the right hand column, my lord, at page 23, fourth, my lord, entry from the bottom. In 1982-83, South Point High School, Calcutta had an enrollment of 13,000 regular students. So, my lord, my name appears, my lord, in the Guinness.
Where?
My lord, fourth entry from the bottom, my lord. School at page 23, my lord, right hand column. Right hand column, my lord. School largest world. My lord, somewhere here.
Yes. South Point is.
South Point. Lordship sees, my lord. My lord, from page 24 onwards, my lord, are my registration certificates. My lord, I am having multiple registrations over my mark, my lord. My lord will find page 25, my lord. It's registered under class 9. My lord will see at page 25, my user is from 1st of April. On the left-hand side, user since, Lordship, at page 25, my lord. User since 1/4/1954, my lord. Lordship knows, my lord, the principal test, my lord, is the first user. First in the market test, my lord.
And
From
registered on?
1954, my lord. Lordship will see in the mark South Point on the right-hand side, my lord.
Yes. And registered on?
My lord, this registration was, my lord, in 2019. This registration, my lord, is of 2019. 6th of March 2019, my lord. Lordship will find just 3.
Yes.
My lord, then page 27, my lord, is another registration, my lord. South Point, my lord, will see word mark. Page 27, my lord.
Yes.
So word mark South Point, my lord. Again, my lord, the user claimed is from 1965. Registration is
19.
of the year. No, my lord. This registration is of the year 1995.
Renewal, okay.
That's renewal, my lord. The registration is of the year 1995, my lord. 26th of July, 1995.
This is with regard to?
My lord, South Point.
South Point.
Word mark. Lordship will see just below that trademark type word, my lord.
Yes, word mark.
Word mark, my lord. South Point. Then, my lord, 29 again, my lord. This is under class 19. This is also registration granted, my lord, in my favor in the year 1995, my lord, of the word mark South Point.
Why so much registration?
My lord, it's under various classes, my lord. If Lordship sees, this is under class 18, 16, my lord.
1 p.m.
Lordships have another matter.
How much time you take?
My lord, I will take some time, my lord. But if my lord wants me to come back some other day, my lord.
I will. 2 बजे का matter है? 2 p.m. you're at?
Yes, my lord. I can come at 2 p.m.
Mr. Gupta is very weak.
Mr.
It's a
Gupta.
special division bench specially sitting, my lord. It's a review, taking up a review, my lord. A specially constituted bench at 2 p.m. my lord.
Review.
No, I'm sorry. It's the honorable bench taking the review. It's a specially constituted bench for that at 2 p.m. of.
मेरा वो भी है.
Possibly Lordship also has a division bench at 2.
I'm saved. But I was hoping that the disclaimer would have solved the issue, but Mr. Jain's client.
He's telling that you remove your South Point.
That
or either South or Point.
I shall show that South Point is there even in hotels in Las Vegas, and also, my lord, there are other schools and, my lord, steel companies.
Schools I will not.
Manufacturing.
They have hotels in Las Vegas and Timbuktu also. Doesn't matter.
Sense appearing for the plaintiff, sense appearing for the defendant. Counsel for the plaintiff has argued at length, but due to paucity of time, argument could not be completed. Fix 9th April.
Great. 9th April. Deeply applied.
My lord, my application, Lord, you will kindly remember, my lord, that application by the Administrator General and Official Trustee of West Bengal with regard to the property, my lord, located in Jharkhand, my lord, in Ranchi. The property which was given on tenancy, that it belongs to a trust, my lord. That trust is under the supervision and maintenance of the official trustee, Administrator General and official trustee of West Bengal. Now, my lord, this property measuring around 59 decimals of land was given on tenancy, my lord, in the year 1952 to the then Bihar Electricity Board, my lord. Then subsequently to bifurcation of the two districts of Bihar and Jharkhand, my lord, this portion came under the Jharkhand, my lord, state of Jharkhand, and ultimately Jharkhand Electricity Board is in charge. My lord, on an inspection subsequently, my lord, there too, my lord, it was found that the electricity board is not giving, not paying any rent. It was rupees 80 only nominal, and that 1952. But then they are not paying rent for over decades. Number one. Number two is when it was found that they have also parted with possession of that property to third parties, even including political offices, etc. Everything was found there. Apart from their office located, the entire property is now totally in the hand of third parties. Now, my lord, thereafter, my lord, when the inspection took place, we took a survey of the property in Ranchi, being physically present there. My lord, then we came back, my lord, then there are 5 parties from Jharkhand. They gave proposal to purchase this property on as is varies and whatever there is basis, my lord. And one S.N. Manzar, the gentleman, my lord, he gave an offer, my lord, that at that point of time was 9 lakhs per kata. He was willing to offer, my lord, subject to, my lord, the whatever encumbrances are there, he will take care. Now, my lord, the Administrator General at that point of time said that offer was, he felt a little low also. Now, subsequently, we received an letter from Mr. Manzar, who has offered to, my lord, pay 10.5 lakh per kata, my lord. So that will be, my lord, around 35 katas. The trust will be benefited. It gets to around, my lord, 4 crores or something. I put it on fixed deposit, you know, that you can earn at easily, my lord, more than 2.5 lakh rupees per month. That benefits to the trust. On the last occasion, I was moving this matter, my lord, one learned advocate appeared.
I appeared for the.
Yes, and she, my lord, what as I've understood, my lord, on the last occasion, she made a submission that she is appearing for Jharkhand Bijli Mantra, that Mantranalaya, well, that's board, electricity board there. When she submitted on the last occasion, subject to what she says today, that they want to take it, they are continuing with the tenancy. Well, I've taken specific instruction. My client does not want to give this on tenancy and continue with this tenancy as well. Because of the fact, my lord, firstly, for over decades, they have not paid any single paisa as rent, number one. Number two is it was found on a physical inspection that they are almost parted with the property, even accepting their offices and all. Now, the remaining portion of the property is now in the hand of third parties. So now, what do I do? Well, supposedly I continue in the drain. Well, all these parties, it's not physically possible to maintain this property from Calcutta. They are in Ranchi. So we want to, well, we are not disposing them. If they are there, they are there as it is. We want to dispose it of on as is varies and whatever there is basis, they will be there. Now, whosoever is the purchaser will deal with them. They may continue the tenancy with that. They are the state. Now, that was my humble submission that kindly permit us, my lord, to dispose of this property on as is varies basis. On the last occasion, my lord has also indicated that lordship was thinking that since this property belongs to a trust, so lordship was thinking that there should be a public auction. So in that event, my lord, I was thinking that I can give an advertisement in Ranchi, and then, my lord, there can be bidding, and these people who are offering also, they can also come forward and take part in the bid. As a matter of fact, my lord, this electricity board in 2011, this is part I find from the records also, they themselves offered to purchase this property.
Your lordship,
So
still
if
we
they
want
purchase,
to purchase the property.
if they purchase, then there's no difficulty. Whosoever let them purchase at the circle rate, then no problem, my lord, I'll give it to them. So these are my submissions.
Lordship, still we are interested to purchase your lordship, and this land may be sold as in wherein basis, because we cannot be evicted in the process of a probate proceedings, your lordship. We are in possession, which is an admitted fact. Our possession may not be disturbed.
So what is your submission with regard to if the land is auctioned?
Your lordship,
as is where basis.
as a tenant, we were requesting that the first offer should be made by us, so that we may purchase, because we are in possession.
That's why telling that the 4 point some crore is there, other party. If you are ready to pay, then you place the your quotation.
Your lordship,
That's why on the last occasion,
I've taken instructions. They are interested in purchasing the property.
Purchasing it because they are otherwise. That's why I wanted
And
that.
it cannot be at market value, your lordship, because
They have parted with possession and now they come and say it.
That's why I wanted. Otherwise, I will go for the publication, and you can also participate.
Your Lordship, let it not be a paper public auction. Your Lordship, we may sit with them and try to negotiate the offer, and some time may be given for that. And if that doesn't work out, then a public auction may be done, and our possession may not be disturbed.
Because the trust property.
We are not disturbing them.
Maybe the other party is giving the 4 crore, but the court has to see. It is to be said that trust property.
Let them come up with a better offer also.
If you come with a better
Let
offer.
all the offers, prices may be given so that we know as
No.
what are the-
Why? It cannot be.
Because we are a tenant, we are in possession.
Correct. Now he is telling that the 4 point some crore. You inform your party.
Let them give their offer.
Give your offer. Then we'll see to that.
Your Lordship.
Lord, kindly take it up then next week, Lord. Let them in the meantime, Lord, give their offer.
Your Lordship, next week only 2 days are working, so
Yes.
some more time may be.
My lord, in this matter, my lord, my client, your lordship, they are interested in the property.
You are appearing for?
My lord, I'm not a party to this proceeding, your lordship. My lord, I made an application, my lord. My application was
That
allegedly
application,
rejected,
yes.
but no order is being passed to it.
Correct.
But, my lord, my client is interested to purchase the property.
That's why you are interested to purchase the property. There is no problem.
Yes, lordship.
But see, this is a trust property.
Yes, lordship.
Correct. And this case has been filed under the Administrator General Act.
Yes, lordship.
Correct. And the court, once the offer has come, the court cannot say, yes, this can be accepted.
Yes,
the
lordship.
court has to go by the large scale on that.
Yes, the best thing is to go for publication.
Now the party who is in possession of the property, they have some right to give their offer.
Lordship.
To give their offer. So if they have come forward, they are telling that they wanted to settle the matter. So I am fixing after 2 weeks. Let they come sit with the party. If they are settling it, it is okay. If it is not settled, then automatically the court will pass an order. Then their offer will be not settled. But then the
allegations against them is very grave.
But my lord,
the
he is
allegation
nobody.
is they parted with
My lord,
possession of the trust property. How could they
my
do
lord,
that?
this party,
Yes,
this party has come forward. He wants to trade with this property. He doesn't have even a single paisa to buy. He says he will now
That is not
get
the
in touch.
concern,
No,
no,
that is
my
his
lord.
offer.
That
I'll
is-
get in
that is
touch
not the
with some
concern.
promoter friends there and who will be investing money, and then I am to buy.
That's why I'm telling. That's why this court was of the view that
Lordship.
Everyone does
if
it.
it will go on auction, then
Yes,
if
yes.
it will go on auction,
Yes.
there will be a procedure.
Lordship.
If the auction, if the parties come, they have to deposit the amount.
But
the amount is to be there. They will not come forward for payment. That amount will be forfeited. Then the second lowest will be taken.
That's the usual procedure.
Second highest, sorry. Yeah.
Lordship.
Second highest is to be
Lordship.
taken. The
Lordship.
procedure is to be adopted.
Lordship.
I'm appearing for SN Manjari, your lordship, who has already participated, your lordship. Lordship, what has just been submitted before this honorable court, your lordship, I have already submitted amount of rupees 10 lakhs and odd, your lordship, for per kata with regard to that. Your lordship, let that be taken on record, your lordship, and in the meantime, what has just been submitted, lordship, they may also give their own offers, your lordship, which 3 of them or many others can be considered.
That's why I'm telling. I am not taking all this thing on record. Let first the party is coming forward. Let they sit together. If they're settling the matter, then it's okay. Otherwise, it will go to the public auction. What 10 lakhs, 20 lakhs? What is the seized
Lordship,
amount?
I have participated pursuant to the public notice itself.
When it was published, no.
Lordship, the public notice was given, your lordship, pursuant to that I have participated.
When it was published? How
No.
it was published?
But, a
No.
notice was there, which was
No,
hung
that
up
was a
on- at
notice
the
which
premises.
my lord, the Administrator General went for physical inspection of the property.
Notice was hung
And
up
their
there.
survey was carried out. And my lord, we put up a notice board that this property belongs to is under the maintenance, supervision and maintenance of the Administrator
Lordship,
General. So looking at that advertisement, which is put up at the site, well, all these offers have came. They are all local people.
Participated on the basis
I,
of
I will take
advertisement.
note of it also.
Yes,
I
yes.
will take
That
note
offer
of
has come, and till now, my lord, her client is the highest offerer. They have offered 10.5 lakh. They announced to 10.5 lakh.
Lordship, it may not be directed that our offer may be disclosed to all. Lordship,
No,
they
I
may
am
come
not
up and make their own offer.
at this, I am not passing any order only with regard to taking time for settlement by
Lordship.
And Lordship, we had applied to purchase it on as it is basis. That is, your Lordship, if I may be allowed to make one submission that the tenancy can continue.
That is up to you and the
Lordship,
person who is in occupation of the property.
My lord, kindly keeps in the first week of April, my lord, the parties may sit in the meantime, and my lord, will inform your lordship of the outcome of the meeting.
You are appearing for the Jharkhand Bijli Vitran
Bijli Nigam.
Vitaran Nigam Limited. That's a full name actually.
Bijli Vitran Nigam
Your
Limited.
Lordship.
Limited. And so and so appearing for you are appearing for
I'm appearing for SN Manjar.
one series SR Manzar.
Yes.
SR
E
Manzar. And you are appearing for
Lord, I am appearing for.
Acha, your application is rejected. Police.
Lord, it was not known. It was not made known to me.
Police.
I
The
think later, Your Lordship.
council for the Jharkhand Bijli Vitran Nigam Limited submit that some time may be given to settle the issue with the petition. In view of the submission made by the council for the Jharkhand Bijli Vitran Nigam Limited, the case is adjourned for 2 weeks. Release the matter on 5th of April 2020.
Lordship, a time may be fixed, Your Lordship.
Yes.
So, Lordship, may kindly gives a time, Lordship. Very kindly.
Now I am not fixing the time because of the, let you come, I will take the matter.
Lordship.
Lordship, time may be fixed at 1 p.m.
Lordship.
Because counsel from
That's why I will-
the additional advocate general from Jharkhand.
If you want the time, then it will go to the last week of May. That is the problem. Last week of April. That's why I am not giving.
4:30 also we.
No, if the learned additional advocate general is coming, participating in this hearing, my lord, then kindly fix a time, my lord.
Time comes from. At 1 p.m.
Lordship.
Grateful.
My Lord rises.
My lord, today the 330 matter, my lord, this is a suit matter where I am in reply, but I am facing some embarrassment, my lord. There is an appeal court matter which has also, my lord, coincided with 330. In case I am unable to make it, my lord, kindly grant, because my learned junior is also stuck there, otherwise he would have continued. I know with how...
Which for the other side?
Well, I'll inform Mr.
Lordship,
Ghosh.
I am for the
There, I'll inform Mr. Ghosh.
Your witness.
Yes, they're the other side.
They are
But
with
it's
the-
in
for the
reply,
plaintiff.
final
Acha,
argument.
evidence.
Final argument. In case I am unable to make it, my lord, kindly, my lord, because, my lord, unfortunately, it was supposed to be at 3, but I understand today it has come at 3:30, my lord, then appeal matter before court 6. Okay. I'm just informing in advance. I'll inform my lordship.
Your Lordship, pleasure to pass the order in item number 2, my lord, in the daily list. Item number 2 in the daily list. The defendant is also appearing, my lord.
Item number 2.
My lord, in the non-commercial, my lord, is for
Acha,
for
orders.
passing orders.
All the orders. Item number 2. Leave is granted to the defendant to produce the document relied upon in paragraph 5(1) to 5(7).
Much obliged.
One liberty I was asking for, in the event plaintiff is also allowed to adduce some of the documents. Some new documents. In the event plaintiff is also allowed to adduce some combat with these.
Come with the application. In this, how it can come, that will see. Yes. Another.
Was returnable on 19th March under the heading.
Is off.
My Lordship, this matter was returnable on 19th March under the heading suits, but it just went out of the list. It's not appearing, my Lordship.
Answer tomorrow morning, madam.
I will. Grateful, my Lordship.
With Lordship's kind leave, may I mention item 4 of the regular list, Your Lordship?
Yes.
Lordship, this matter, Your Lordship, on the last occasion, Lordship had directed me to serve upon the defendant. Lordship, this
Item
is my
4.
Item 4 of the regular list, Your Lordship, for orders.
Yes. So what do you want?
Lordship, in this matter, Lordship, I have served upon the defendant, but Lordship, I have given to understand that the advocate of the defendant, Your Lordship, is no more, Your Lordship. So, if Your Lordship, I have been told by the junior that they are not even able to contact their client. So, Your Lordship, in that event, may I be directed to serve directly upon the defendant, Your Lordship?
Direction is.
Otherwise, Your Lordship, it will not be fair.
So that's why on the last occasion the order was passed. Inform the next date. Then
Lordship,
after some of the defendant, the matter is listed under the court is of the view that would not be proper. Is the matter under the heading orders. The plaintiff is directed to inform the have you informed the next date to the defendant?
Lordship, I have informed upon the advocate of the defendant, Your Lordship, and his clerk also has received the Lordship, the notice. But your lordship have given to understand that the advocate is no more your lordship. So may I be permitted to serve directly upon the defendant?
Miss Pooja Jevakaja. What is her name?
Jivrajka, lordship. Pooja
Jevarska. Learned advocate appearing for the plaintiff through virtual mode submits that in terms of the order dated 14th March 2024, the counsel for the plaintiff has informed the advocate on record of the defendant, but the advocate on record of the defendant is not appearing in the matter. Accordingly, she prays for leave. She prays for a direction. She prays for leave to inform the next date of hearing to the plaintiff, to the defendant directly.
Lordship.
In view of the submission made by the counsel for the plaintiff, the plaintiff is directed to inform the next date of hearing to the defendant directly and to file the affidavit of service on the next date fixed. List the matter on 15th April 2024 under the heading orders.
Grateful, lordship. Deeply obliged.
And
Item number 2, since the entire order was not read
But my lord, the inspection and discovery as well as the additional admission and denial affidavits are to be completed, my lord, if that line can be added in the order. Because new documents will be produced, my lord, the inspection, discovery and admission of additional admission of affidavits. Additional affidavit of admission and denial and inspection and discovery prior to that.
Inspection, I have to also prepare an affidavit of document in that.
Okay, I will see. But that consequential order may be passed in the order series.
Thank you.
Before uploading it. Deeply appreciated.
Fine, take care. जजमेंट नहीं भेजी मैडम, सुनेगा लाए थे। नंबर 1 application dismissed.
Lordship has dismissed the application. Great.
My lord, this is my application.
Yeah.
Challenging my lord, or taking exception to the report of the my lord special referee. The directions were issued for filing affidavit. We have not yet been served with any opposition.
The affidavit is ready. We are out of time. I'm praying for extension to file it till today. It's ready, my lord.
Saw the copy?
No, my lord.
But since it was out of time, I think they attempted service yesterday.
Yes,
Mr.
we
Agarwal
tried
did
to,
not take it.
sir,
My lord, if he files it, my lord, today, my lord, gives me 2 weeks time to, my lord, use a reply and come.
Yes, my lord, it's না, ফাইল তো করতে হবে। Mr. Basu is so happy with the first item getting dismissed that he has got a wrong brief.
But unfortunately, today is a Thursday, not the Friday.
এটা আমাদের কপি রিসিভ তো করতে পারবো না রেকর্ড করিয়ে দিন লর্ডশিপ we have been given a copy lordship may record that
Okay. So appearing for the plaintiff, so appearing for the defendant. You are for the plaintiff.
I am for the plaintiff.
I am for the my lord defendant my lord it's my
Plaintiff has filed affidavit in opposition in connection with GA 5 of 2024 after serving the copy to the learned counsel for the plaintiff.
No, my lord.
Counsel for the defendant.
Defendant.
Let the same be kept with the record. Full stop. Counsel for the defendant prays for time to file reply
within 2 weeks my lord by 4th of my lord April.
within 2 weeks. Full stop. Let affidavit reply be filed by 4th April. List the matter on 9th of April.
Grateful.
My lord, item number 5, my lord, I am appearing for the plaintiff petitioner in this matter. My lord, here, my lord, on the last occasion, the defendant, my lord, after repeated service, they appeared. And my lord, they wanted to seek time, my lord, to file affidavit in opposition to my lord, to my application for judgment upon admission. My lord, here, my lord, this petition, my lord, my humble submission is, my lord, it should be in the commercial division, the plaint, because, my lord, the disputes are commercial in nature. My lord, I am an NBFC company. My lord,
When you file the suit,
2019.
then
2019.
you file a suit in 2019. How the suit can be transferred directly?
My lord, in 2019, when I filed the suit, my lord,
At that point of time, this commercial court has been established.
23rd October 2015.
And section 15, if
Only for
pending
pending cases.
it can be transferred. Now you filed in the before the wrong forum, then it is your choice. The court
my lord,
cannot. The court cannot unless the other side is agreed for that.
No, lordship, I will.
Other side is not agreed, is taking the benefit of that.
I have a demurrer point on that.
my lord, the demurrer, there is no, my lord, despite repeated, my lord, orders passed, they have not filed any objection. No
The
affidavit
application
in
under
opposition
12.6,
filed.
not the
Yes.
suit.
No, that is with regard to the application. What about the suit? Now you are telling that the suit is of commercial in nature. If
My
the
lord.
suit is of commercial in nature, how the interlocutory application can be heard by this court? And
lord.
secondly, you are praying for the transfer of the suit, but it is you are filed in 2019. That is after the establishment of the commercial court. So the court Soboto cannot transfer.
My lord,
Either
very well.
you have to take appropriate application, whatever it may be. Then they will get an opportunity.
Very well, my lord. My lord, in that event, my lord, kindly grants us time, my lord. We shall come up with an appropriate application for transfer, my lord.
So appearing for the plaintiff, so appearing for the defendant, so appearing for the plaintiff through virtual mode. So appearing for the defendant, counsel for the plaintiff prays for time for taking appropriate steps. In view of the submission made by the counsel for the plaintiff, the case adjourned for 2 weeks. This is the matter on 11th of April.
Lordship, let it go out of the list, Lordship, when they file their application.
Otherwise, I have to pass a
Lordship.
My lord, we shall take steps.
Whatever it may.
My lord. Obliged, deeply.
Grateful, my lord.
I appear for the petitioner, my lord. This is my injunction application, which has been heard, my lord.
Injunction application is allowed. Defendants are restrained from transferring, alienating, or creating any third-party interest in the disposal of this.
Lord, agreed.
Seven, I'm for the plaintiff.
Yes.
This presentation of plain, my lord. The plaintiff and the defendant are the husband and wife, my lord. The husband has filed a divorce petition before the Asansol court on 17th October 2023. But what wife has done, my lord, as a counter blast, she has filed another divorce petition on the same self cause of action before this in US.
US.
In US. But I am praying for an anti-suit injunction in this plaint. Upon presentation of plaint, the application will be filed, my lord.
Decree mandatory. How you can?
Yes, my lord. I have a Supreme Court judgment that says it can be done.
You take.
My lord, operative portion is at paragraph number 8 to 10.
Yes.
And facts of the case are more or less similar.
Hmm.
My lord, kindly come at page number 18. That is the plaintiff's divorce petition, my lord.
Page number 18.
18 of my plaint.
18.
18.
Yes. This is filed by you.
Yes, filed by the plaintiff.
Plaintiff.
But and Page number 24 is the order passed in that suit.
What
Da-
order passed?
Service of the summons order
Admission. Yes.
dated 18th October 2023.
Under section 27 is special marriage.
Yes, yes. Marriage was solemnized under special marriage.
Special marriage.
Yes. In 2016.
Then
But then on the next
someone
page,
served.
yes, my lord, summons was served. But on the next page is the petition that has been filed by the defendant before the Court of California in US. My lord would find the date at the right hand side top, electronically filed by Superior Court of CA County of Santa Clara on 10 October 10, 2023.
20th October 23.
Yes. That is then prior suit, not before our suit.
Huh?
But our suit was filed prior to
That's
that.
when you filed this suit?
But my suit was filed on 17th October 2023. An order was passed on 18th October 2023.
18th October 23. And this was filed?
This was filed on 20th October 2023.
20th October. Yes.
Facts of the case are more or less similar to the judgment I have shown before the Supreme Court.
What you prayed for?
I prayed for anti-suit injunctions.
Anti-suit injunction. So appearing for the plaintiff. Plaintiff has filed a suit praying for a decree of mandatory injunction against the defendant, her legal heirs, successors, administrators, assignees, agents, relatives, friends, servants, employee, henchmen, and executors, HENCH henchmen, and executors, restraining her from instituting and/or pursuing matrimonial legal proceeding against the plaintiff before the Superior Court of California, County, County of Santa, Santa Clara, CLARA, Clara. Counsel for the plaintiff submit that plaintiff has filed a matrimonial suit number 706 of 2023. There is no family court in Asansol.
No,
Before the
it was transferred from the family court to the
before the London district and session judge at Asansol. And subsequent to filing of the suit, the summons white order number 1 dated 18th October 2023. Summons was issued against the respondent wife. Full stop. Counsel for the plaintiff submit that the plaintiff and the defendant are the husband and wife, and the defendant, being the wife, had also filed another suit against the plaintiff before the Superior Court of California, County of Santa Clara, 25, on 20th October 2023, which is admittedly after the suit filed by the plaintiff. Full stop. The plaintiff has relied upon the judgment passed by the Honorable Supreme Court, reported in 2021, Volume 2, SCC 775, wherein the Honorable Supreme Court held that wherein the Supreme Court in the similar proceeding has passed an order restraining the respondent from proceeding with the pending suit instituted by the wife in the Superior Court of Arizona, ARIZONA, or to file any other proceedings, including interim applications, if any, Consider the submission made by the counsel for the plaintiff, produce the plain document and the judgment denied by the plaintiff. Police. The suit is admitted. Issue writ of summons.
Deeply obliged, ma'am.
A plaintiff to take appropriate step for reasons of writ of summons.
Deeply obliged, ma'am.
My suit.
Admitted. Yes.
The suit is for, well, suit concerns the management and administration of a society, which is the defendant number 1. Well, today, well, I am praying for leave under Order 1, Rule 8 of the Code of Civil Procedure, as well as Order 2, Rule 2 of the Code of Civil Procedure.
Why?
Well, why Order 1, Rule 8 is because, well, the interest of the public at large, who are the members of this society, are being affected, including of the plaintiffs. Well, and the plaintiff has a direct interest in the administration of the society, which is the defendant number 1. And well, it is in the nature of a representative suit because if the wrongdoing the suit for Malad is well, I'm praying for declaration that the annual general election Malad held by the respondent number 1, the defendant number 1, is bad in law. And Malad, all decisions taken pursuant to such election Malad, and by the committee which has been formed pursuant to such election are bad in law. Malad, that is a declaration I want. I seek in the suit and an permanent injunction restraining the present post holders or the office bearers from discharging any duty to run or administer the society.
There is the provision of the election petition.
This election petition will not. It's a registered
The
society.
registered society.
Yes, it's a registered society. Well, that is the suit. And Malad, since Malad, it is in the representative.
When the election was held?
The election was held in October. And thereafter, Malad, there have been communications between the parties. And I've also taken out a motion where I will be praying for certain ex parte orders for inspection of certain documents.
What are the grounds you have taken?
But in the motion, what the why I say that the election which has been held was bad in law is that it was contrary and in violation of the bylaws of the society. Yes, there was no notice at all within the 4 corners of the bylaws.
Granted.
Leave under Order 1, Rule 8 and leave under Order 2, Rule 2. Lordship will also consider making a direction for publication in the newspaper because that's
let it be admitted. Well, then we'll see to this.
Very well. Very well. Grateful. The motion is also GA1 is also appearing along with
Let
item
it
A.
admitted, then you mention, then it will be taken up for hearing.
But if
it is
we are
mentioned today, it is listed today.
yes, it is there in the list. If your lordship kindly fixes that application on any date, we are some urgency in the matter and we will be seeking ex parte orders. But we will not take much time of your lordship, at the most 15 minutes.
Leave is already granted to the plaintiff to file the suit. It is fine from the record. The plaintiff has filed an interlocutory application being GA1 of 2024. Let the same be fixed on 4th April.
4th April. Grateful, madam. Well, lordship will be kind enough to fix a time on 4th of April. It's a regular division.
That's not I.
A regular division, that is why I was. Very well, we'll come back. Grateful.
Now you will get time. I said fix that way. You will get.
My lord, I understand. Grateful.
I'm for the petitioner. In this matter, your lordship was already, my lord, passed an order and disposed of the application. Now, my lord, it is very embarrassing for me, my lord. At the time, my lord, the order, my lord, there is a certain typographical mistake in the my lord, order sheet. My lord, your lordship, I am annexing, your lordship granted me leave to file my supplementary affidavit. I annexed the order. My lord, the only one word was, my lord, change. The facts are everything, my lord, is correct, my lord. The only thing, my lord, instead of, my lord, the letter of administration, the probate was, my lord, recorded, my lord. That has been, my lord, corrected, my lord. Everything is right, my lord. Kindly see the order dated, my lord, June 22, 2023.
Your application for grant of probate.
Grant of letter of administration, my lord, the facts are everything is only thing, my lord, instead of probate, my lord, it should be, my lord, letter of administration.
So how it is disposed of, sir?
Disposed of, my lord,
Not the correction.
correction
Court
is
has granted probate. Now you are telling that the letter.
no, my lord, your lordship, your lordship has passed an order, my lord. You will mention that the testator Purnachandra Mondal has executed his will and testamented by appointing his daughter Mayara as the sole executix. And he has died. My lord, so since the executive was died, my lord, that should be, my lord, letter of my lord, administration. My lord, your lordship has mentioned that, my lord. The executive.
Kindly come to the paragraph first one of the judgment, second paragraph 2.
The testator Purnachandra Mondal has
No.
filed a present application for grant of probate, my lord. That is the wrong typing, my lord. Instead of probate, my lord, it's
Then you come to the last paragraph. Come to the last
yes,
paragraph.
my lord, there is a, my lord, the only the word is probate is, my lord, instead of letter of administration, it should be recorded as a probate, my lord. But my lord, fact or everything is recorded because, my lord, after the demise of, my lord, executive, my lord, his legal layers, my lord, it should be, my lord, the letter of administration because your lordship has mentioned that.
I fully appreciate
My lord.
that the court has, but by this way the order.
No, I am filing an application for modification, my lord. That is why your lordship granted me leave.
The application.
My lord, the application is, my lord, in the, my lord, file, my lord, and your lordship granted leave, my lord, to file a supplementary affidavit. The
application.
Yes, my yes, my lord, application is there, my lord. Modification and correction of the, my lord, order dated 12th of June 2023, my lord.
The petitioner has filed the present application being GA3 of 2024, praying for modification of the variation of the order passed by this court. Variation of the order passed by this court dated 22nd June 2023. Full stop. Counsel for the petitioner submit that the petitioner has prayed for grant of letters of administration, but while passing the order, this court in paragraph 1 of the judgment has recorded that whether your application was modified to amended for grant of probate or not, grant of letters of
That,
administration.
my lord, my application for letter of administration, my lord. But I have the original copy of the application also, my lord.
You that?
Yeah, my lord.
Letters of administration, but in the order dated, in the judgment now, in the order dated 22nd June 2023, recorded that the petitioner has filed the present application for grant of probate. Simultaneously, in page 2, paragraph 4 and paragraph 5, also this court has recorded that the petitioner is entitled to get the probate and also directed and also recorded that probate be issued after the payment of ad valorem court fee. Full stop. Consider the submission made by the counsel for the petitioner. Peruse the application and peruse the application, comma, order dated 22nd June 2023. Na? 2023 and the probate application, PLA application number 40 of 2019. After going through the application, this court find that in prayer E of the PLA, the petitioner has prayed for grant of letters of administration. Accordingly, the order dated 22nd June 2023 is corrected as follows. In paragraph 1 of the order, in paragraph 1, page 1 of the order shall be read as inward comma. The petitioners have filed the present application for grant of letters of administration of the last will and testament testament of the deceased Purna Chanda Mandal. And instead of then again inward comma, the petitioners have filed the present application for grant of probate of the last will and testament of the deceased Purna Chanda Mandal.
Third line from the bottom, my lord, that is also, my lord, probate, my lord.
Where?
Third line from the bottom.
Which application?
This is third line, my lord, the first page.
Which page?
First page, my lord. First page, my lord, third line from the bottom, my lord. My lord,
एक काम करो, counsel for the petitioner बोला ना? हाँ, consider the submission. Last. No, prior. ना कितने उससे पहले क्या बोला? Grant of production accordingly the order dated 22nd June 2023 बाकी कटे थे 23 is recalled and the following order is passed. Semicolon. The counsel for the petitioner has filed with होगा खाली probate होगा. ये probate की जगह letters of administration ठीक है. बाकी ये term है grant of probate letters of administration and इकोने entitled to letters of administration and it is one record the petition is not on the petition not whether requisite for in court and this is last paragraph. Letters of administration be granted to the petitioners subject to petitioners of subject to furnishing surety of rupees 1 lakh with one surety. Letters of administration be issued after compliance of all formalities. GA number 3 of 2024 is disposed. Yes.
Instead of a word of probate, not related to us. And deeply obliged.
Yes, call next.
Let a short matter for amendment. Short amendment.
Fixed matter.
I appear for the defendant in this matter.
For the plaintiff.
Yes.
না আজকে হবে ট্রাই করবো শেষ করে দিচ্ছি but pursuant to your lordship's leave, my lord, we had filed a supplementary judge's brief of document. There are, my lord, about 10 documents in that judge's brief. But today, my lord, I'll show the witness to
None of these documents were disclosed in proper time.
No, absolutely, my lord. They were inspection. Most of them are admitted by
My
the
lord,
inspection.
they have made two applications. Your lordship remembers, my lord, for disclosing commercial suit for disclosing documents.
Correct.
Your lordship granted leave, but these documents were not disclosed.
Why?
They are saying these are certificates, but Be that as it may, these are documents.
You could have been served the copy.
Not only served, they have taken inspection. Probably my
My lord,
landlord got
leave was
properly
my
instructed here.
leave
They
was
have
not
taken
given
inspection.
for these documents to
Which
come.
document? If the lock, which
all-
document are you have
My lord,
produced?
there are, I have tell you, Lordship, the Lordship has the JBD in Lordship's hand, my lord.
Huh?
Lordship has the judge's brief in your Lordship's hand, my lord. The supplementary one.
Ah.
Where the first, second, third, fourth, fifth, sixth, seventh are admitted by them in the inspection. The annexures to some emails have been denied. Remaining, every document is admitted, 7 except one document which Lordship last time allowed in GA number 9. So that I'll prove here in court.
Now, what you enclose with the certificate? What
The
is
cert-
denying
the
that?
certif- that
What is
certificate
denying
is,
that?
that certificate is under 65B.
What document you didn't apply?
All the documents that are there in G8 and 9, only those documents, because others are already proved in evidence.
These certificates also should have been disclosed because these
Certificate,
are
I
also
don't,
documents.
certificate I don't need to disclose an affidavit.
The affidavit. That is the affidavit.
Why do I need to disclose my affidavit? I don't understand this.
That is 65B. You have given the copy to you.
They are given copies.
Of course, I have to give the copy. Otherwise, how can I do this matter?
Yes.
So the documents that have been admitted by them in inspection, those may be not marked as exhibit by consent of parties because there is no denial in respect of these documents. I'll tell you, Lordship, from the JBD, from the judge's brief, Milord.
Yes, we have document of
Yes, sir.
supplementary.
Supplementary judge's brief, Milord. Lordship would find-
Supplementary.
Supplementary. The other judge's brief, Milord, has been completed. From the supplementary list, item number 1, 2, 3, 4, 5, 6, and 7 are all admitted documents admitted by them in inspection.
There's no admission in inspection.
Inspection, where is the admission?
I tell you, Lordship.
They
Inspection.
have admitted, it's fine. Let my
May I
lord
hand
finish the
may I hand over the inspection, Milord? So, Milord, this is Milord the Lordship can see its existence contains custody, issuance, everything has been admitted. All of these have been admitted. All of these for the first 7 documents. So I'm saying I don't need to prove them one by one. Those will be marked exhibit. The admitted documents.
No, 1, 2, 3, 4, 5.
Yes, 6, 7.
6 also, but 7 is 6 also. There is a part.
Yes. The annex, those are annexures to the email. Those I'll have to prove. Miller, I'll put questions to the
Invoice
witness.
letter 26, they have denied that.
Yes, that the ones where they are denied, I'll prove them here with the witness. The ones which are admitted, that is what I'm indicating, Miller. Serial number 1 to 7 of the.
Show the
Yes.
document.
Rohit Srivastava. ROHITSRIVASTAVA. TAVA.
I am showing you a document appearing at pages, the copies whereof is appearing at page 1 of the supplementary judge's brief of document. Please tell my lord, what is this document? Document.
My lord, the same is the letter issued to ECGC Limited, dated 22nd July 2016, wherein we have enclosed the checks for
गर्मी नहीं लगती
processing fees
इसी नहीं चल
and advance premium of the customization policy. We have also enclosed the check for advance premium of ETP policy merging into the customization policy.
Where is the original of this document?
The original of these documents are in the custody of ECGC Limited.
But, since this has been admitted, Lord, may this be marked as exhibit DD.
What was the last one?
CC was the last.
DD.
I am showing you
Page 1 of supplementary. Yes.
22 जुलाई 2016 page 1 है যেটা। I am showing you an original document appearing copy whereof appearing at page 2 of the supplementary judge's brief of document. Please tell my lord what is this document.
My lord, this is the premium receipt dated 27 July 2016, acknowledging the premium paid for the customization policy. Yes, page 2.
Where is the original of this document?
My lord, this is the original of the document.
This was again admitted in so this may be marked as exhibit EE.
Exhibit E. Double E.
Double E. I am showing you copy of an original document. I'm showing an original document, copy whereof is appearing at page 3 of the supplementary judge's brief of document. Please tell my lord what is this document.
My lord, this is the premium receipt dated 27 July 2016 for the renewal of ETP policy. Renewal of ETP policy.
Where is the original of this document?
My lord, we have the custody of the original document and I tender it.
But since it is again admitted, so maybe
FF.
FF. I'm showing you. I'm showing you copy of a document, printout of a document, copy whereof is appearing at pages 4 and 5 of the supplementary judge's brief document. Please tell my lord what is this document.
My lord, in page number 4 and 5, page number 4 is the forwarding email from Vikram Solar Limited to MAH International. This is the forwarding email from Vikram Solar Limited to MAH International, advising them to help in collecting the outstanding amount based on the recommendation of ECGC Limited. Page number 5 is the letter dated 2nd February 2016 issued by MAH International to issued by Vikram Solar to MAH International, wherein the company has stated the details of the overdue amount from Total Green Energy Limited and requesting to help in collecting the outstanding amount based on the recommendation of ECGC Limited.
Have you filed any certificate in support of these printouts? Have you disclosed any certificate? Have you disclosed the due certificate in support of these printouts?
Yes, my lord.
My lord is there.
Sorry, sir.
Lord, these are also admitted. May these be collectively marked as exhibit GG. These two documents, two emails to be collectively.
Exhibit GG collectively.
I am showing you printout of a document, copy whereof is appearing at page 6 of the judge's brief of document. Please tell my lord what is this document. It admitted. Email. No.
Yes.
MAH International.
My lord, page number 6 is the email dated 9th February 2016 sent by Sweta Sharma of ECGC Limited. Sweta Sharma of ECGC Limited to Niladri Shah of Vikram Solar Limited, wherein a request was made to provide the entity details which is managing the warehouse. Further, the role of JAS forwarding, JAS forwarding in the consignment transaction along with the copy of agreement with the said global entity was requested.
Have you disclosed the due certificate in support of this printout?
Yes, my lord. The certificate has been disclosed.
This has also been admitted through inspection and discovery. May this be marked as not exhibit HH.
What is the in between? What are the two documents denied that is not connected with this?
No, not yet. The next
No,
email.
in the column 6.
Yes, one of them has some attachments. Those attachments, they have to prove. They're saying there's some agreement.
That is not here.
No, that is in the part of the.
I'll come to that then. It's the next document.
That is the only thing we've objected. They should prove that just because it's an attachment to someone else's email, it can't go.
Yes.
I am showing you printout of a document along with printout of an email along with the annexures attached therewith, copies whereof are disclosed at pages 7 to 19 of the supplementary judge's brief of document. Please tell my lord, what are these documents? 7 to 19, supplementary judge's brief.
My lord, page number 7 is an email dated 10 February 2016 sent by Amit Prasad of Vikram Solar Limited to Sweta Sharma of ECGC Limited in reply to email dated 9 February 2016, wherein the company has informed that Vanguard Logistic has been appointed VANGUARD. Vanguard Logistic has been appointed by JAS Forwarding for managing the warehouse. JAS Forwarding is looking after the import clearance, warehousing, and distribution of material. Page number 8 is the disclosure of the information on the global entity. Page number 9 is a copy of customs invoice cum packing list, wherein the exporter is Vikram Solar Private Limited, Palta SEZ, Kolkata, and the consignee is Vikram Solar Private Limited, care of JAS Forwarding Worldwide. Page number 10 to page number 19 is the copy of warehousing agreement and custom formalities agreement dated 16th July 2013 entered between Vikram Solar Private Limited and Jazz Forwarding Worldwide Belgium NV. Belgium NV. NV. NV.
How are you aware? How are you aware of the document appearing at page 8 of the judge's brief of supplementary judge's brief of document?
My lord, page number 8 to page number 19 is the attachment to the email dated 10 February 2016 sent by Amit Prasad of Vikram Solar Limited to Sweta Sharma of ECGC Limited. I have personally obtained the email along with the attachment from the office computer.
What do you say? What do you say about the contents of these documents, these annexures?
My lord, the contents of the annexure are true and correct.
Please come to page 8 of the supplementary judge's brief of document and tell my lord whether you can identify the signature appearing in this document.
Yes, my lord. The page number 8 has been signed by Mr. Niladri Shah, who was looking after the international business of the company.
How do you know his signature?
My lord, I'm aware of his signature in the usual course of business.
How have you, please come to page number 9 of the supplementary judge's brief of document and tell my lord, how have you received this document?
My lord, page number 9 was the attachment to the email dated 10 February 2016 sent by Mr. Amit Prasad of Vikram Solar Limited to Sweta Sharma of ECGC Limited. The said invoice was obtained from the office computers.
Have you disclosed any due certificate in support of this
Yes, my lord.
document appearing at page 9 of the supplementary judge's brief of document?
Yes, my lord. The due certificate has been appropriately provided. Appropriately provided.
Due certificate.
Yes.
What is the due certificate?
The certificate is due to be filed. I have prepared it and disclosed, and I'll be filing it.
Due certificate as in
Due to be filed.
Due, it is due. So now he has
means proper mixing it up. As far as this document is concerned, the email can go in. We are objecting to the
other annexes.
Now, if they want to prove those agreements, they have to disclose that document and prove it. He said himself that it's an email received by someone and sent to him, and he has downloaded that. So I don't know. My learned friend is asking questions on those attachments. If he wants to prove
Let's see.
those documents,
Let's see what he's telling.
I'll answer this once I finish the last one in the list. Please come to page 10 of the supplementary judge's brief of document and tell my lord who are the parties to this document.
My lord, the parties to the warehousing agreement and custom formalities document dated 16 July 2013, appearing from page number 10 to 19. The parties to the said agreement are Vikram Solar Private Limited and Jazz Forwarding Worldwide Belgium NV.
What do you say about the contents of this agreement?
My lord, the contents of the agreement are true and correct.
What was your involvement in preparation of this agreement?
My lord, since I am the DGM Finance in the company, so the contents of the agreement were drafted and discussed with me before sending to Jazz Forwarding Worldwide Belgium NV. The signed agreement was the printout of the signed agreement was taken by me personally from the office computers.
Please come to page 18 of the supplementary judge's brief of document and tell my lord whether you can identify the signature appearing in that page.
Yes, my lord.
18 and 19. 18 and 19. Signatures appearing in those pages.
Yes, my lord. The signatures appearing on page 18 and on page 18 is of Mr. Bruno Gerardis. Bruno
BRUNO.
BRUNO Gerardis GERARDIS, who is the managing director of Jazz Forwarding, and the signature appearing on page number 19 is of Mr. Jan Suykens, Jan JANSUYKENS, who is the Ocean Import Manager of Jazz Forwarding. Ocean Import Manager of Jazz Forwarding.
How do you know? How can you identify these two signatures?
My lord, I'm aware of the signature in usual course of business.
What do you say about the contents of this agreement?
The contents of the agreement are true and correct.
That this three annexures, well, email is admitted.
Yes.
Three annexures, my lord. First one is at page 8 of the supplement.
Page 7.
7 is admitted. 7 is email is admitted.
So page 7.
Email says three annexures. So
Email dated February 10, 2016 be marked as exhibit.
it should be F
Double I.
Now the documents at 8, 9 and 10 to 19. These are three annexures where the witness has identified the signatures. I am carrying the copies of the documents. The witness has identified the signatures, has said about the contents, and also said that these are true and correct, and he is aware, and he is also he was involved in participation of these documents, the preparation of these documents. So since witness has identified them, these may be also marked as exhibit subject to objection, as he said last time done. Objection may be recorded, obviously, but since witness has identified these three documents.
But he has only received the document.
No, in one document, the first one, the third one, page number 10 to 19, he says that he was involved in the preparation of this, and he has signed this and sent it to.
No, he
that
has
party.
not signed it. He has prepared and given them. It is not signed in his presence.
He said he has kindly, if Lordship sees the.
Yes, sir,
It was
he had discussed it. But
I have
it's not
prepared,
even
discussed and sent for.
Yes, and he has identified the signatures appearing there. So the one signature missing is the signature of the plaintiff only. And I am the plaintiff. He is the witness of the plaintiff. He identifies this, agrees with the content. The other two signatures of the other party. And those signatures have been identified by him saying, I know the signatures in usual course of business. So there is no doubt about the preparation, execution, and signature of this document. So far as the question of the other two documents, pages 8 and 9, these have been taken printouts from the computer. Now, because of this, we are filing the affidavit of under section 65B, the certificate. We are filing that. I have a copy of it. So, in support of that, these may also be proved in evidence.
With regard to the signature of plaintiff, okay, is the plaintiff witness, he can
Yes,
identify.
yes.
With regard to
18, there's no signature of the plaintiff.
Only plaintiff signature is missing. That's what I'm saying.
plaintiff signature is not there. And with regard to the other two person, then they're not in India also. How
No,
he can
their
identify?
signature, he says that I have seen usual course of business, I have seen them.
He can see, he has seen, but with regard to the document in question.
And that is what I'm saying, let the objection be recorded. And subject to objection, this may be marked as an exhibit.
How?
Because thereafter they can take these points.
He's not the party to the document, sir.
That if he is involved in the preparation of this document,
Preparation he has given, but not signed in his presence. It is not signed in presence, and your plaintiff has also not signed. If your plaintiff would have been signed, then it can be taken into consideration.
if I be Lordship, permit me, my lord, to hear the statement of the witness once, because I think he said that it was signed and sent to them. It's like just
only stated that I have prepared and sent it for signing.
May I only suggest this to my learned friend? The email will go in as exhibit.
That has been exhibited.
And subject to objection that the attachments have not been proved. If the email goes in, it's the attachment. I'm not disputing that. It might be the attachment. But the attachments are a separate agreement. He should produce the agreement and prove it separately.
Correct. That's what I'm telling you. This is a copy.
Page number 8.
As an attachment, he can't prove it like he was trying to do.
Page number 8 has the signature of the plaintiff. Is an employee of the plaintiff itself.
See, this is not the original document.
The original
You have received through mail.
I have sent them through mail.
Through mail.
Yes, I have not received them. I have sent them through mail.
Original gulo tu produce kar. You produce separately. You prove them.
Yes.
But these documents have been prepared. Document itself prepared in computer in an electronic device. AMLOT sent from computer to through electronic device to another electronic device. I have taken a printout of these 3 documents from the same electronic device. I have given a certificate in support of that. So, original is in the electronic form. I cannot create a document which is not this. Electronic signature and send.
This is electronic signature.
It is not.
This particular.
No.
This particular page 8. Page 8.
As page 8, it is a seal and signature. It can't
This
be.
page 8 is scan copy. I am disclosing the scan copy. That's my evidence. It's my signature, my employee's signature. Page 8. I have identified this signature.
And with regard to that also, page 18 and 19 also, it is not an electronic signature.
That this document, only my signature is missing.
Your signature is missing,
Yes.
but you are in Calcutta.
I am in Calcutta.
Correct.
Yes.
These 2 persons are not in Calcutta.
No.
This is in foreign country.
Yes.
Correct. And it has been received. It is not signed. These parties are not signed in his presence. And his plaintiff has not signed.
Yes.
So how it will go?
He hasn't produced the original
And also the original is not
the
here.
certified copy of the
Lordship then Lordship kindly mark them as mark for identification.
As per
I can even then I can yes.
That is better.
Very well.
As per identification, you will go. If you want to produce the original and it can be exhibited.
But I think in fact this agreement was earlier shown once, and that this was already marked as Exhibit X.
X for identification.
That is not recorded, but
See,
Exhibit X with objection, it was recorded. Question number 120. 120.
Anutosh, Exhibit X. Exhibit X.
Question number 120. That's not recorded here. Only Exhibit X. Question number 120.
No, अपना नहीं.
Email goes in as
क्या है? बताओ.
Email to has already been marked as an Exhibit II. तो करे दिए
and subject to our objection to the attachment.
Exhibit H, Exhibit X, question number 120. बताओ करने हो question number 120 बोले तो आप कुछ धमकाने वाला सुविधा करते जाओ बड़ा सुविधा कुछ है
Yes, Exhibit X with objection.
Yes, well I am
Then why you want
yes I am only saying that this process may be repeated in respect of the other 2 documents. Subject to objection, exhibit. Once done, the same document. If Lordship reads the answer given in question number 120, kindly read the answer once for my satisfaction. The document was signed by Bruno such and such, sent over email to Vikram Solar for execution. We took printout of the said document, and document was signed on behalf of Vikram Solar and sent over email to Jazz. Document has been photocopied from the attachment of
the
email.
agreement need not to be taken into consideration.
Yes.
Already
Yes, and other 2 may be not be marked as exhibit subject to objection. The same process may be followed. That's what I'm submitting.
Now, give the 108. Question number
120.
120.
Kindly read the answer once, for finding my satisfaction.
Let me see. If it is so, why you have to again put this? You could have been shown
Because
this
it's
document
annexure. With
for
part of an annexure, I had to. Otherwise, it will be incomplete document. I had to show.
120.
Yes, 120. This was also separately disclosed, but because it's part of the annexure of an email, I can't disclose the email incomplete.
Yes, that is over.
Yes,
Then
so that document, the remaining two, same process will be followed, subject to objection, marked as an exhibit. Same process will be followed, my lord. This will not prejudice anyone, my lord. My learned senior friend can still take this point.
Yeah.
But Ashif has already marked the email as II. May that be marked as II collectively,
No.
subject to objection.
No.
Very well. Separately then.
Last, what was the last exhibit?
The email was II.
G. J with objection. J with objection. Page number
8 and 9.
8 and 9.
So 8, 9 and the rest.
The rest has been
That is
already.
also, he has date to prove it. It's exhibit X, I'm not worried. My learned friend should have
He's
taken
not
all
taking.
three and separately. As far as the contents of
8 and 9. You're taking the 10?
10 minute already. I don't.
You want to take the
I
10?
don't need to, minute. It's already marked an exhibit. I'll rely upon that exhibit at the time of argument.
No.
And Millard, the email has been marked as an exhibit without objection. So Millard, when I rely upon the email, these documents will I'll also rely upon them in the trial, Millard.
With objection, huh? Yes, next.
I am showing you printout of a document appearing at page, copy whereof is appearing at page 20 of the supplementary judge's brief of document. Please tell my lord, what is this document?
My lord, page number 20 comprises of an email dated 19 February 2016 sent by Sweta Sharma of ECGC Limited to Amit Prasad of Vikram Solar Limited, requesting to provide certain documents, that is, full set of export documents, the name of global entity involved in the transaction, experience sheet with details of buyer and overdue position from the buyers.
Have you filed the required certificate? Have you disclosed the required certificate in support of this document, this printout?
Yes, my lord. The required certificate has been disclosed.
But this has been admitted in inspection and discovery. May this be marked as an exhibit.
Exhibit.
Double K
Yes, next.
I am showing you printout of a document appearing at page 21 of the supplementary judge's brief of document, along with the annexures attached therewith, appearing at pages 22 to 31 of the supplementary judge's brief of document. Please tell my lord, what are these documents?
My lord, on page number 21 is the reply to an email sent by Amit Prasad of Vikram Solar Limited to Sweta Sharma of ECGC Limited, wherein the full set of export documents along with summary of the shipment made from India to Antwerp, Antwerp, along with the payment, the time taken to realize the payment has been provided. The name of the global entity was disclosed as Jazz Forwarding Belgium. The experience sheet along with the overdue position was also attached. Page number 22 is the copy of the customs invoice cum packing list, wherein the exporter is Vikram Solar Private Limited, Palta SEZ, and the consignee is Vikram Solar Private Limited, care of Jazz Forwarding Worldwide, Belgium, NV. Page number 23 is the copy of non-negotiable bill of lading dated 25th July 2015, wherein the shipper was Vikram Solar Private Limited, Falta SEZ, and the notified party was Vikram Solar Private Limited, care of Jazz Forwarding Worldwide. So you just mark it page number 23 and 24, okay, together. Yeah. Page number 25 is the export declaration form required to be filed with the customs authority at the time of exports. Page number 26 is the copy of purchase order from an entity called Solar King UK to Vikram Solar Private Limited for purchase of 700 panels having a total value of $99,750. 99750. Page number 27 is the copy of commercial invoice dated 20th August 2015 with exporter as Vikram Solar Private Limited, Palta Special Economic Zone, and consignee as Solar Crown UK Limited.
Yes, next.
Page number 28 is the packing list for the goods sold to Solar Crown UK Limited. Page number 29 is the copy of certificate of foreign inward remittance, INWARD, inward remittance, issued by State Bank of India for USD 331066, certifying that the payment has been received from Solar Crown UK Limited. Page number 30 is the details of the shipment made along with the terms of payment and the date of realization of payment. The reason for delay in payment was also mentioned in cases where there has been delay in payment. Page number 31 consists of the details of the overdue position from various customers, along with the overdue amount and the due date.
Can you please tell my lord, how have you obtained the just before that, my lord, the email appearing at page 21 that has been admitted by them in inspection. So that may be, my lord, marked as exhibit LL, the email. I'll be asking him questions regarding the annexures. Thereafter, my lord, may those annexures be, my lord, also marked as exhibits subject to their objection, as is done on the last series. My lord. Email may be, my lord, this is without objection. Email should be marked as exhibit LL.
Which email?
The first page 21.
Page 21 LL, and the attachments are marked for identification. That's how. Well, I was thinking that if I send all my documents to my learned friend by email tomorrow, and then he says, yes, I admit that I've got, then I don't have to do anything else in the suit. It's gone in as an exhibit along with that email. So he has to prove the contents of this. He's showing a bill.
I have not finished questioning. I said, no, I'll ask questions on these documents.
Tried to prove it.
No, I have not yet asked any question. I said
First you
email may be LL. Remaining I'm doing.
First you complete
Very
it.
well.
Okay, email dated?
Email dated 2nd February 2016.
February
2016. Page 21.
22nd February 2016, appearing at page number 21 of the supplementary judge's brief document.
As far as your lordship may record my objection that I object to the attachments.
But I have
because
not come to
That
that
I am not taking.
Because the originals have not been produced.
That I am not taking.
Oh, very.
But I've not come to the annexures yet.
That I am not taking.
The part of the same email.
Yes, but I'm doing it
But
separately.
he's not taking that.
You have
He's taking separately.
Then he has to produce the original document.
But this has been dealt separately.
Okay, you continue.
I am kindly come to page 22 of the supplementary judge's brief of 2 of the supplementary judge's brief document and tell my lord, how have you obtained this document?
My lord, the document appearing on page number 22 has been obtained by me personally from the office computer.
Are you what do you say about the contents of this document?
My lord, the contents of the document appearing on page number 22 are true and correct.
Where is the original of this document?
My lord, the original of these documents are in our custody.
How have you sent this document to the defendant in the suit?
My lord, the said document was sent over an email to the defendant.
Can you identify the signature appearing in this document?
Yes, my lord. The signature, the customs invoice has been signed by Mr. Sanjeev Tulsian of Yes. Tulsian of Vikram Solar Limited, and it has been certified by Mr. S.T. Bhutia, who is the superintendent of customs.
Please come to page 23 of the supplementary judge's brief document and tell my lord, how have you obtained this document?
My lord, page number 23 and 24 comprises of the bill of lading. The said non-negotiable copy of bill of lading has been obtained from the office computer. Has been obtained from the office computer. Has been obtained by me personally from the office computer.
What do you say about the contents of this document? This document?
My lord, the contents of the bill of lading are true and correct.
Where is the original of this document?
My lord, we are required to submit the original of the documents to the bank for issuance of FIRC.
Please come to page 25 of the supplementary judge's brief document and tell my lord, how have you obtained the How have you obtained this document?
My lord, I have obtained the export declaration form, export declaration form appearing on page number 25 from the office files.
What do you say about the contents of this document?
My lord, the content of the document are true and correct.
Where is the original of this document?
My lord, the original export declaration form is required to be submitted with the bank for issuance of foreign inward remittance certificate. Inward remittance certificate.
Can you tell, my lord, who has signed on the documents appearing at pages 23 and 23 to 25? Who have signed?
My lord, the document appearing on page number 23 and 24 has been signed by the representative of NYK Line India Private Limited, NYK Line India Private Limited, Line India, yes, India Private Limited, who happens to be the carrier for the goods shipped. Page number 25 has been signed by Mr. Pinaki Sen Gupta, who is the preventive officer with Indian Customs.
Please come to page 26 of the supplementary judge's brief of document and tell, my lord, how have you obtained this document?
My lord, the purchase order appearing in page number 26 issued by Solar King has been obtained by me personally from the office computer.
What do you say about the contents of this document?
My lord, the contents of the document are true and correct.
Where is the original of this document?
My lord, the purchase order has come over an email to Vikram Solar Limited. So this particular document was, the printout of the said document was taken from the email and office computer.
Can you identify the signature appearing at page 26 of the supplementary judge's brief of document?
My lord, the purchase order has been signed by the representative of Solar King.
Please come to page 27 of the supplementary judge's brief of document and tell, my lord, how have you obtained this document?
My lord, the document appearing on page number 27 is the commercial invoice. I have personally taken the photocopy.
What do you say about the contents of this document?
The contents of the document are true and correct.
Where is the original of this document?
My lord, we are required to submit the original commercial invoice along with the bill of lading and other document to the commercial invoice along with the bill of lading, customs invoice, packing list, and export declaration form to the bank for obtaining foreign inward remittance certificate.
What do you say about the contents of this document?
My lord, the contents of the document are true and correct.
Please come to the can you identify the signature appearing in the document?
Yes, my lord. The commercial invoice has been signed by Mr. Niladri Shah, who was looking after the international business of the company. International business of the company.
Please come to page 28 of the supplementary judge's brief of document and tell, my lord, how have you obtained this document?
My lord,
yes.
my lord, the packing list appearing on page number 28, I have personally taken the photocopy of the same from the export file. from the export file.
What about the contents of this document?
My lord, the contents of the document are true and correct.
Can you identify the signature appearing in this document?
Yes, my lord. The said document has been signed by Mr. Niladri Shah, who is looking after the international business of the company.
Where is the original of this document?
My lord, the original packing list has been submitted to the bank for obtaining the foreign inward remittance certificate.
Please come to page 29 of the supplementary judge's brief of document and tell my lord, 29. Tell my lord how have you obtained this document?
My lord, I have personally taken the photocopy of the certificate of foreign inward remittance issued by State Bank of India.
What do you say about the contents of this document?
My lord, the said certificate is issued by State Bank of India after verifying all the invoices and the payment confirmation. The contents of the certificate are true and correct.
Where is the original of this document?
My lord, the original of the FIRC is in our custody.
Please come to page 30. Just act a questioning. Can you identify the signature appearing in this document? Page 29.
Yes, my lord. The certificate of foreign inward remittance has been signed by representative of State Bank of India.
Please come to page 30 and 31 of the supplementary judge's brief of document and tell my lord, how have you obtained these two documents?
My lord, I have personally taken the printout from the office computers.
What do you say about the contents of this document?
My lord, the contents of the document are true and correct.
How are you aware of the contents of these two documents?
My lord, since I am the DGM Finance in the company, so I am aware. I am the DGM Finance in the company, DGM Finance in the company. So I am aware of the overdue list and overdue position and the details of sales made by Vikram Solar Private Limited.
Where are the originals of these two documents?
My lord, these documents were sent over an email to ECGC Limited.
Can you identify the signatures appearing in these two documents?
Yes, my lord. The said document is signed by Mr. Niladri Shah, who is looking after the international business of the company.
That the annexures to the email appearing at pages 22 to 31 that be marked as exhibit subject to objection of the.
It will take me half an hour, but each and every document none of them have been proved. The originals are with them. They don't produce the original. He said that these are attachments to an email. My learned friend again repeats the question, where did you obtain the documents? He said he's obtained it as the attachment of the email. These particular pages cannot be proved. Well, let them be marked for identification. My learned friend will consider the questions. None of them he's the author. None of them bear an original signature.
Yes.
None. He identifies everyone from Belgium to State Bank to everybody. We can all read, my lord, but it's not for anything else. Man, I don't think that email has gone in subject to objection.
Correct. He's not the document.
He has to prove it.
Not the witness to the document. Okay, he has obtained and he can produce. But only producing the document cannot be
all marked
exhibited. He is not the party to the document.
May I make one submission? In respect of two documents, he said originally is in our custody. Remaining are all filed. He said in the answers, remaining are filed with the State Bank. Some are filed with the other department authorities of Government of India, and some came from the other side. So the originals can't be with us. So I have to rely upon the photocopies, and I have disclosed those photocopies in the JBD. I also have further copies in my hand. Now, so far as these two documents, the original question of disclosing the original does not come here. So far as his knowledge is concerned, knowledge of the witness, he says that I am holding this authority in the plaintiff company. So I am aware of these entire proceeding and how these are calculated and what.
That is not
So
denied.
these are there. Right. So only thing I'm saying that since already we have taken that process of marking documents as exhibit subject to objection, that just
No,
because
sir,
of
see,
just
subject to objection with regard to what if he is the person and original is not there. But here he is now. He has only received the document through the mail and he has print out and produced before this court. How it can be exhibited?
But
He's
even
not
if
the party to
I
the
am
document.
I am submitting that even if those are exhibited, those the contents are not proved just merely by marking it as an exhibit. That point will be kept open in any event. He is not the witness who can prove the contents of this document because he is not the signing authority.
That's why let's
authority.
let's
He said,
prove the
he said.
document.
So let them be marked as exhibit subject to objection. Objection will obviously they will be because the other one Lordship has seen the question of 120 that I shown.
That's why I don't know what it has been exhibited. But once a fault has been done, you cannot take the benefit
I'm
of
saying
that.
the same process may be followed
No.
for marking of exhibits because that won't change anything. So far as their objections are concerned and the
This is the
value of the document is concerned.
electronic document. That not means you take out the print and bring this court as I know the contents and it can be exhibited. If you are the party to the document, it's okay. It is a through mail and he has sent, he has received, that is okay. But he is not the party to the document. You prove the document. It can be taken on as expert identification, wife for identification. You prove the document through the proper witness or whatever it may be. Otherwise, tomorrow anybody will come. Yes, I have taken the print and they are correct.
So that lot, that is why I'm saying that contents I can't prove. This
Correct.
witness at least can't prove the
So
content of the document.
why it should go to the exhibit?
Oh, so that I can rely upon them at the time of argument. That's the only purpose. Otherwise, exhibit marking of exhibits of a document would not serve any other purpose than disclosing them in the evidence.
No.
Otherwise, there is no such purpose. So that's the only purpose.
You prove it through the
Very well, Lordship. Mark these documents as
page number.
Page number 22. The documents which are very well 22 to 31.
22 is already exhibited.
21 is exhibited.
21 exhibited.
Yes, LL. And 22 to 31.
22 to 21, Y for X for identification.
I don't, yes, it should be Y for identification collectively.
X or Y?
X,
earlier X was there, no? X for identification.
X आगे है नहीं? আমি বলছি তো X.
There is a separate exhibit. There was one
X for identification is there.
Yes,
X for identification.
But I've instructed that there is already.
Subject to correction, there was one document which was X.
Yes.
That's why I'm asking whether X for identification is there.
Yes, it's there.
My instruction is there is one document which was already earlier marked as for identification X.
If it is X, then
are
Y.
being written, there will be no confusion. The documents from page 22 to whatever is marked for identity.
22 to
31.
31. Y for identification.
Question number 54, it was marked, one document was marked.
Y for identification. Yes. Next.
I am showing you.
How much time you will take further?
2 more documents. I am showing you a printout of a document appearing at page 32 of the supplementary judge's brief of document. Please tell my lord, what is this document?
My lord, page number 32 is a copy of an email sent by Sweta Sharma of ECGC to Amit Prasad of Vikram Solar Private Limited. Amit Prasad of Vikram Solar Private Limited, informing that based on the scrutiny of all the information and documents provided for proposing to cover the export transaction under CGE policy is rejected and ECGC Limited cannot provide cover under the CGE policy for such export transactions.
I have to, my learned friend can't show this document because your lordship's order says the email of 13th January 2023. This is, that is the blank email on top of the page. I don't know if that page is being shown.
No, 13 January is there.
Yes, but this is he's proving of 30th March. They should have taken leave for that. They took leave for that. Now this is an attachment to 13th January. That's how my learned friend is seeing it, I suppose.
No, no, I'm not. I have disclosed it as Lord. If Lordship reads my supplementary judge's brief, kindly see the serial number.
What the document has been allowed?
Serial number 9. Serial number 9. I have marked as 30th March 2016. Supplementary JBT.
My lord,
And
if
Lord,
you kindly come to your lordship's order dated January 16, 2020.
Give the order date. Give the order.
January 16, 2024.
Should have corrected it.
Yes, yes.
And in the third paragraph, my lord, the plaintiff has filed the present application, such and such, praying for leave to disclose and rely on a document as appearing at page 22, which is an email dated 13 January 2023. And therefore, my lord, your lordship allowed that email only in the entire order. But the email dated 30th March 2016 was not allowed. So they cannot rely on this on this email. And my lord, the witness is answering on that email of the 2016 email.
The only thing I can not show from the application itself, what was my prayer. Lordship passed an order, but my Lordship allowed my application. In the application, otherwise it will generally waste the time
What
of the
was the document? Your document might have been annexed with the application.
Yes, yes.
Document was
This was annexed. The Lordship allowed this. My land friend, I don't know why he is taking this application because his inter opposition was on this document. Kindly sees the otherwise I don't want to
will
put
kindly see the order, my lord.
No, that's why I'm telling what is the document on
Yes,
that.
I am carrying GA9, my lord. Waste of time, otherwise, my lord, yes. Kindly this
Page 22. What is the page 22?
Page 22, my lordship sees page 22. I had disclosed this document. The same document I am disclosing here. She can tally. My lord. This email at the top is a email pursuant to filing of the suit. Naturally, I won't rely upon that. So she tallies these two pages same.
No, my lord, I'm in a different point. Page 22 was not allowed. What was allowed is the email. The email dated 13 January 2023 was allowed. If your lordship, they can come up with a point, yes, that in the prayer in the master summons was allowed.
Of course, that's prayer. That's my prayer. Page 22.
Yes, but my lord,
kindly read the master summons.
The directions has to be read with the observations in the order, my lord.
Absolutely not, my lord. Lordship has allowed my lord, prayer A of the master summons. The master summons says, my lord, that page number. Naturally, the page number
In
is
the
allowed.
view of the prayer, A to C is allowed.
So prayer A was that page 22.
Yes, my lord, but it has to be read with the observations, not that only what directions were made.
No, what, my lord?
Pair A to C, pair A to C is page 22. Page 22 is there.
My lord, page 22.
So the court has recorded.
What he will achieve by taking this point, I don't know. Everything, we were all aware of this.
Continue.
Who has issued this email?
My lord, the email was sent by Shweta Sharma of ECGC Limited.
To whom it was addressed?
This email was addressed to Amit Prasad of Vikram Solar Private Limited.
What do you say about the contents of this email?
My lord, the email was sent by Shweta Sharma of ECGC Limited to Amit Prasad, and it was forwarded to me, the printout of which was taken by me. So I cannot comment on the contents because the printout of which was taken out by me. I cannot comment on the contents of the email sent by Shweta Sharma to Amit Prasad, since the email was sent based on their internal scrutiny and policy.
Can you tell, my lord, whether the defendant has ever denied this email? Denied
my
the
lord.
existence of this email. Whether the defendant has ever denied the existence of this email.
This is the why you are putting this question.
Well, this was the email was admitted in the affidavit in opposition. At the time of argument, I'll take this point. Yes, very well. Then let it be marked.
Objected to it because he hadn't
Let it be marked as an exhibit because they are not objecting.
That's him asking.
Yes.
Exhibit, what is the exhibit?
M. Last question. I am showing you. I am page 32. I am showing you a document appearing at page 33 of the supplementary judges. I am showing you the original, an original document, a copy whereof is appearing at page 33 of the supplementary judges brief of document. Please tell my lord, what is this document?
My lord, the said document is the extract of the minutes of 14th Legal and Tendering Committee meeting of Board of Directors of Vikram Solar Limited held on 30th November 2021, wherein I have been authorized by the committee to depose and provide the evidence on behalf of the company in the matter being CS 141 of 2019.
What do you say about the contents of this document?
My lord, the contents of the documents are true and correct.
Can you identify the signature appearing in this document?
Yes, my lord. The document has been signed by Mr. Sudeep Chatterjee, who is the company secretary of the company.
How do you know his signature?
My lord, I am aware of his signature in the usual course of business.
But let this document his power of the authorization of the witness blood N. Well, I don't have any other document. Only the 3 formal questions I have to put because of the plaint and the certificate. Yes, I'm completing it right now. But, I am showing you.
Give the print.
I am showing you an affidavit affirmed on 24th of what is this? There to show the affidavit. Sir, may I get the affidavit once, minute?
Which affidavit?
The last affidavit that I have filed, certificate 65B.
It is filed.
Yes, Milord.
When you have filed today?
No, Milord, in the last occasion. Copy nahi hai. In the old. Just একবার আমাকে দিন। Okay, don't take copy part. I am showing you an affidavit affirmed on 8th March 2024. Please tell my lord who has affirmed this affidavit.
Have you got the copy?
Yes, Milord. We have served upon.
Leading question, he shouldn't have said affidavit, but anyway.
I didn't say whose affidavit. I only said an affidavit. I said who has affirmed it. Please tell that.
My lord, the affidavit has been affirmed by me.
He has kept it in suspense. Who has affirmed this?
Who can please tell my lord who has prepared this affidavit?
My lord, the affidavit has been prepared by our advocates. It has been affirmed by me.
Who has instructed the advocate of the plaintiff to affirm to prepare this affidavit?
My lord, I have instructed the advocates to prepare this affidavit.
I have instructed the learned advocate to prepare it.
Are the contents of this affidavit true and correct?
Yes, my lord, the contents of the affidavit are true and correct.
I am showing you another document. Please tell my lord what is this document? Affidavit of evidence type of document. Affidavit of evidence type of document. affidavit of evidence যেটা ফাইল করেছিলাম ওটা দেবে।
Is the commercial?
Yes, yes. হুম, ওই জন্যই তো বললাম, ওই জন্যই তো বললাম না বলে দিলাম। এই যে, কোশ্চেনটা কি করেছিল? What is this document?
My lord, this document is the affidavit of evidence affirmed by me on 1st December 2021.
Who has prepared this document?
21. My lord, the document has been prepared by learned advocates.
Who has
by instruction.
last year until লিখলেন তো? What do you say about the contents of this document?
My lord, the contents of the document are true and correct.
Whose affidavit? Can you tell, my lord, who has affirmed this affidavit?
My lord, the affidavit has been affirmed by me.
একবার প্লেনটা দেখুন, প্লেনটা। দেখে নিচ্ছি লাস্টে। I am showing you the copy of the plaint filed by the plaintiff in this proceeding. Please come to page 39 of the page 40 of the plaint and tell my lord, page 40, and tell my lord who has affirmed this affidavit. Page 40
My
of the
lord,
plaint.
the affidavit appearing on page 40 of the plaint has been affirmed by Mr. Anirban Datta of Vikram Solar Private Limited.
Please come to page 39 of the plaint and tell my lord who has verified this plaint, the contents of this plaint.
My lord, this has been the contents of the plaint has been verified by Mr. Sandeep Agarwal of Sandeep Agarwal and Company.
What are you saying?
Okay, sorry. It has been verified by Mr. Anirban Datta. The Sandeep Agarwal.
Then says. Then says. That's why I am also thinking.
Please tell my lord whether the contents of the plaints are true and correct.
Yes, my lord. The contents of the plaint are true and correct.
How? Please come to page 40 of the plaint and tell my lord whether you can identify the signature appearing there.
Yes, my lord. The signature, I hereby identify the signature of Mr. Anirban Datta. I'm aware of his signature in usual course of business.
Please tell my lord what the plaintiff claims in the instant suit?
My lord, in the instant suit, the plaintiff claims a value of rupees 2,28 lakh 42,785 rupees and 35 paisa, along with the court fees of 50,000 from ECGC Limited on account of claim filed in respect of Total Green Energy Ireland.
May the witness be discharged, my lord, from the examination in chief. We have prepared a list of exhibits because the lordship remembers at the beginning we did not file the documents here. We only shown the documents from the judge's brief, Lord. But Lord, now Lord, I was carrying the originals all throughout. Now Lord, we have the originals which were produced, and Lord, the supplementary documents of the supplementary judge's brief. Lord, some originals have been given today as well. So I have prepared a list of exhibits for our convenience. I can Lord, I can, there are
For
three.
what?
For, because, they have been, the chief has been done for 5 or 6 days. So, various documents have been marked here and there. So, I have made a compilation of the exhibits and the documents, 2 documents which have been marked as for identification. So, I'll supply the copy to them, and then thereafter, I'll file before your lordship, so it will for our convenience. So, you can refer to this document, and I'll update this with today's markings, and then on the next day we'll file it.
Yes.
Along with all the originals which are till now in our custody.
Why you not file the original?
Because lordship had granted us the leave on the first day to disclose from the judge's brief, and thereafter, once this is over, we'll file it together. So on the next day,
You do one thing in terms of you, if you're preparing the list
Yes.
of exhibits,
yes,
file the original along with
yes,
that.
that is what I'm proposing to do.
Serving the copy. To
I'll
them.
supply them the list and the documents.
Along
We'll
with
file
the
in.
document, original document.
Document, of course, I'll file in court, not to them. Yes, yes.
So here.
Yes, to here. I'll supply the copy of the list to my learned friend.
So if I'll say that document original distributor, then you will be difficult.
Which original?
Which are original, which are photocopy, everything I'll mention. I've already mentioned that.
Be marked in the
Yes.
in the
Okay.
judge's brief.
Yes.
If you are
You will
supplying a new
cross-examine,
original, you write
Mr.
it.
Ghosh.
Well,
Not like that.
let this be complete. Any day your lordship keeps
Okay,
it,
step
whichever.
So appearing for the plaintiff, so appearing for the defendant. Full stop. Plaintiff witness is present and examination in chief is resumed. Full stop. During his examination, what documents have been exhibited? How many? During his examination, exhibit EE2, EE, DD2,
Okay.
double M, N. We have marked. Full stop. Examination chief is concluded. Full stop. Due to paucity of time, cross-examination could not be started. Fix. Commercial, na? 19th April 2024.
That's the Friday. That day I have a suit fixed on 19th. It can be 18th or 17th, any day.
19th April is Friday. Another matter is fixed.
Before Justice Arindam Mukherjee especially fixed a suit on that.
Achha.
That's why I remember.
22nd April.
Yes.
For cross-examination.
But has lordship fixed any particular time for this? Or
Commercial.
Yes.
First matter. First stop, sorry.
Grateful minute.
Yes, next.
There was a 3:30 fixed matter, which I was told that my way for the plaintiff in that matter, the defendant sought adjournment today. They mentioned
for the defendant. Mr. Chaudhary has prayed for adjournment.
yes, so
But only reply, na?
yes, only for reply,
Item number
29. I'll only request a short date may be fixed because my clients are getting
that will
restless.
Will.
Yes. Some a lot of adjournments have been taken.
Item number 29. So appearing for the plaintiff, so appearing for the defendant. Full stop. As per the prayer made by the counsel for the plaintiff, Mr. Chaudhary.
No, he's for the defendant.
Counsel for the as per the prayer made by the counsel for the defendant. The case is adjourned. Is the matter on 17th April.
17th April. May a time be fixed, otherwise it will not be called on and my proceeding will remain stuck.
No, there is no time.
Otherwise, only thing that my clients are suffering from long.
For argument, under the argument.
আমি বলেছি জজ সাহেব টাইম দিচ্ছেন কি করব বেল come back.
Yes, next. Yes, Mr. Bari, what has happened?
One personal offense was there in the
Today there is no appellate side.
Yes, my lord. But the personal offense was there at 3:30.
Has she complied with? No.
Yes, my lord. We have
Who is for the other side? Not
I
there.
have already intimated Mr. Robi Disrabi Japan intimated, my lord. The petitioner have received the entire area salary.
Areas has received. Okay, she is present. Okay, come on. Next working day is 29th. There will be no working day. 28. 28, there will be no. 4th April. 4th April. Yes. Item number 11.
My lord, this is my application, my son.
Who is appearing for the 10?
Lordship. 4010. Lordship, I am appearing for the plaintiff. May it be kept tomorrow, Lordship.
I'm appearing for defendant number 1, 3, and 4 in this.
Yes. What is the matter?
Lordship, this is
But I
coming up
believe
for
that they have filed
amendment.
an amendment application, my lord.
So you are appearing for the defendant.
My lord, I'm appearing for defendant number 1, 3, and 4.
Correct. You are any objection? You are having any objection?
No, my lord. It is for changing the address of defendant number 2, who I am not appearing for. Defendant number 2 has not entered appearance yet in this suit.
So you have no objection.
I don't have any objection, my lord. But since I will not be using any affidavit, it must be if it can be recorded that the allegations are not admitted.
Okay. So appearing for the plaintiff. So appearing for the defendant 1, 3, and 4 through virtual mode. Full stop. Plaintiff has filed an application being GA4 of 2024, praying for amendment in the plaint by deleting the address of the defendant number 2 and to incorporate the new address. Consider the submission made by the counsel for the plaintiff. Peruse the application. This court find that the amendment as sought for by the plaintiff is formal in nature and will not change the nature and character of the suit. Accordingly, prayer A to C of the master summon is allowed. Department is directed to carry out the amendment within 2 weeks from date. After the amendment is carried out, the plaintiff is directed to reaffirm and re-verify the plaint and to serve the amended copy of the plaint to the defendants. Though the defendant number 1, 3, and 4 appeared, but have not filed affidavit in opposition, the allegation made therein are deemed to have been denied. GA number 4 of 2024 is disposed of.
Lordship, may I have the leave to issue fresh summons on defendant number 2 after the amendment, Lord?
After the amendment is carried out, the plaintiff is directed to take appropriate steps for issuance of fresh writ of summon upon the defendant number 2.
Grateful, Your Lordship.
Hello.
My lord, I am for the plaintiff. This is my application, my lord.
What is your application, sir?
This is application for recalling the order dated 2nd February 2024, my lord.
What has happened 2nd February?
That they made the fourth statement me that they did not disclose the documents. Already disclosed the documents and the inspection was taken out, my lord.
Who is for the defendant? Have you served?
I have served, my lord.
Where is the affidavit?
Affidavit of documents.
I have been told one Ratnesh Kumar is appearing for the defendant. Malad, he has not come today, Malad. But he's praying for his clerk is asking me to pray for adjournment for today only.
Which matter?
This matter.
This matter.
I served the document. Can you turn to page?
The other side is not here. He's asking for that.
Uncle was sitting before half an hour here.
Not today, not today.
Yes, my lord.
Any?
Yes, only one thing, Malad, whether on the returnable date the contemner will remain present, Malad. His confirmation is not required.
You have stated that you are complied with. Yes. I am taking.
I have prepared the compliance.
I am taking on that day. If it find that it is not complied, then we'll sign. Not necessary because the.
I'm sorry.
But inform on that day. I will record that.
I'm a solar.
Yes, next.
I'm appearing on behalf of the petitioner, Your Lordship. This is my application under section 340 of CRPC.
Why 340? This is
Because,
not the criminal bench, this is the ordinary civil jurisdiction.
Your Lordship, the respondent has committed perjury by stating in in their affidavit in opposition to an application filed by us that they had filed an application under section 10 of the CPC and had annexed an application. But Your Lordship, till date, no application has been filed in the court.
But from the affidavit, stating that the section 10 is filed.
Has been filed.
That is the only allegation.
Yes, Your Lordship.
Is on the basis of that statement when any adjudication was made?
Your
Has he
Lordship,
got the benefit of that?
Your Lordship, the reason being, in that by the way of that statement, it was also stated that since there is a subsisting section 10 application before this honorable court, so our application cannot be heard out.
That's correct.
That was written, and it has been repeated for twice or thrice in the whole affidavit in opposition, Your Lordship.
No, that is correct. But
on the basis of that, there was no adjudication. No.
That there is any adjudication that yes, section 10 and your application will be not be heard.
Your Lordship, finally,
you will file the affidavit.
We will kindly.
Filed? No.
We have not. It is coming up for the first time. Kindly grants us 3 weeks time. 3 weeks time to file the opposition.
Sense appearing for the plaintiff, sense appearing for the defendant. You are for the plaintiff.
Yes, Your Lordship.
Plaintiff has filed an application being GA4 of 2024.
Yes.
Praying for initiation of proceeding against the defendant under section 340 of the Code of Criminal Procedure. Counsel for the defendant prays for time to file affidavit in opposition. Let affidavit in opposition be filed within 3 weeks. Reply, if any, there to be filed within a week or 2 weeks. Within 2 weeks.
2 weeks, Your Lordship.
Full stop. List the matter on 24th of April 2024.
May I file the affidavit?
Affidavit of service filed by the plaintiff be kept with the record.
I'm grateful.
Next.
That I'm opposing this application.
But it's a restoration application.
Milord, only thing that I would want time in place.
Yes, what is your objection?
Objection is, Milord. Cost, Milord. The thing is, my suit, his Order 7, Rule 11, he's the defendant. Now, Milord, I filed the opposition to it in March 2023 for 1 year. No steps are taken. They're not pressing their Order 7, Rule 11. They filed their written statement in the meantime. It's been a year. And then it has been dismissed.
Well, dismissed on absence of both the parties. Not only me.
So you got the benefit of that.
Yes, only.
Hence, I am to oppose, Milord. It's been a while.
Lordship can record his objection to my application. And my Lord, my application can be heard out. My Lord, after being restored, if your Lordship is so inclined, can be heard out.
For me, it has to be heard.
Yes, my Lord, it can be any day. My Lord, I am not dealing the matter.
Sense suffering for the plaintiff, sense suffering for the defendant. Full stop. The plaintiff has filed an application being GA3 of 2024, praying for recalling of the order dated 25th January 2024, wherein this court has dismissed. GA was dismissed.
Yes, no, GA was
dismissed. The GA1 of 2023 for default. Full stop. Counsel for the defendant raised objection and submitted that. The plaintiff. Now you are for the defendant.
My Lord, I am for the defendant. It was my application for rejection of plea.
What? No, upper. Sense suffering for the plaintiff. No, defendant has filed an application. It has filed an application the application 2024. 2023. The counsel for the defendant submit that. And the counsel for the plaintiff raised objection and submit that the plaintiff had filed the application being GA1 of 2023 for rejection of plaint, but has not proceeded with the matter, and accordingly, this court has rightly dismissed the said application for default. He prays that due to the application filed by the defendant, the suit has not been proceeded with. Consider the submission made by the counsel for the respective parties, peruse the application. This court find that sufficient cause has been shown for non-appearance of the parties before this court on the date fix, and this court also of the view one more opportunity should be given to the defendant to proceed with the application being J1 of 2023. Accordingly, the order dated 25th January 2024 is recalled and GA1 of 2023 is restored in its original file. GA number 3 of 2024 is disposed of. Let GA number 1 of 2023 along with CS 232 of 2022 be placed before this court on 17th of April 2024.
The affidavit of service may be kept.
Affidavit of service filed by the defendant be kept with the record.
I'm grateful.
Yes.
Sufficient for the